Hello, and welcome to the County Board of Equalization Training Seminar. My name is Robin Pope, and I currently serve as the Deputy Executive Secretary for the State Board of Equalization. Today, we're going to cover a range of topics, from board operations to how to value properties in Tennessee. But first, we have some other folks who would like to welcome you.
Justin Wilson, I'm the State Comptroller.
Hey, I'm Jason Mumpower, the Deputy Comptroller.
Welcome. We're glad to have you here to learn exactly how to carry out your duties. We're doing this remotely because of transportation difficulties, but we're here to be sure that we have fair and equitable taxation across the state of Tennessee.
Thank you for your service on a County Board of Equalization. You're on the front lines of making sure that citizens and property taxpayers in your county have a right to appeal in case they feel like their property assessment wasn't correct. Your job is very important, and so important that we want to make sure you have all the training you need to do your job correctly. This year, we have all of our training online, and it's online early so that while you're sheltering at home, maybe you can get some of this important training for your service on the County Board of Equalization. Again, thank you. We hope you enjoy the training. We hope you benefit from the training. We look forward to seeing you all again soon.
Yeah, we're here for you to have, people of Tennessee to have fair and equitable taxation, and we appreciate your efforts in doing exactly that.
Hello, I'm Robin Roberts, the Executive Director of University of Tennessee's County Technical Assistance Service. I want to thank all of you for participating in this valuable training program. I also want to thank the Comptroller's Office and the Tennessee Association of Assessing Officers for allowing us to participate in this program. County Technical Assistance Service has two consultants that will be here to assist you as you go through your future work in the Board of Equalization. In any way we can be of assistance, we'll be there to help you. Thank you.
Good morning, and thank you for being here. My name is Will Denami, and I work on behalf of the Assessors of Property. I want to start by thanking the Comptroller's Office for putting together these seminars and for their role in assisting assessors of property across the state. Second, I'd like to thank the State Board of Equalization, whose job is to oversee the process, especially as it comes to appeals, and their role in helping put together these seminars. And third, I'd like to thank the County Technical Assistance Service, or CTAS, which plays a role in assisting assessors of property and other local government officials across the state. I hope you'll take advantage of this opportunity. This is your chance to learn more about the important role that you have as County Board of Equalization members. The assessor of property, as everyone is familiar, is the constitutional officer that is elected to come up with a value for all parcels within the county. As we all know, value is an opinion. And so there is an appeal process every year that all taxpayers can avail themselves of if they believe the value is wrong. The purpose of this is to try to get the value right. So we appreciate what you do. We appreciate your role in this process. Thank you very much.
Hi, I'm Lee Pope, Open Records Counsel in the Office of Open Records Counsel and the Tennessee Comptroller of the Treasury's Office. Today we're going to talk a little bit about the Public Records Act and the Open Meetings Act and how those laws apply to you as a member of the County Board of Equalization. Before we get into those laws, let's talk a little bit about our office, the Office of Open Records Counsel, and how we can be a resource to you as a member of the County Board. Our office was created back in 2008 to help citizens and government officials better understand Tennessee's laws on public records and open meetings. Our office does this by responding to questions and concerns from public officials, citizens, and the media. We do a great deal of educational outreach, such as what we're doing today. We develop a lot of forms, schedules, and policies that deal with public records requests and how to handle those requests. A lot of these resources are on our website. If you go to our website, you can see a lot of our policies and guidelines. We have best practices, a model public records policy, which we'll talk a little bit more about in a minute, schedule of reasonable charges for charging for public records, charges for frequent requests, safe harbor policy. We issue informal advisory opinions occasionally addressing broad meetings or records issues. We post those on our website. We can mediate records disputes. If you have a dispute that can't be resolved with a citizen, we can come in and try to informally mediate that. We also have a records request form and records response forms that can be used on our website. And we also approve internet forums where members of a governing body can discuss amongst each other online. So what are some of the benefits of using our office? A big reason a lot of government entities contact our office is because of this determination of willfulness. If a citizen sues a government entity and the court finds that that government entity willfully denied access to a public record, then that court will impose attorney's fees. If a government entity reaches out to our office and receives our advice, the court will take that into consideration in making this determination of willfulness, and the court might not impose attorney's fees. Also, our schedule of reasonable charges. Pursuant to the Public Records Act, government entities are either supposed to impose their actual costs in producing records, or they're supposed to use our schedule. If a government entity uses our schedule of reasonable charges, those charges are presumed reasonable. Also, we're familiar with these issues. We deal with public records and open meetings issues every day, all day. So odds are if you contact us with an issue, we've probably seen it before. And if we haven't seen it before, we want to hear about it because we need to know about those issues. A big benefit is we're a neutral intermediary. We help citizens and we help public officials alike. So we deal with both sides. And being neutral in that process assists. And sometimes we're in better position to resolve disputes between government and citizens. Last but not least, we're free. So why do we have the Tennessee Public Records Act? The Supreme Court summed it up pretty well back in 2007. It said, facilitating access to government records promotes public awareness and knowledge of government actions and encourages government officials and agencies to remain accountable to the citizens of Tennessee. The Public Records Act is an accountability tool. A lot of people will say, my taxpayer dollars pay for these government operations. You know, those are their records as taxpayers. So the Public Records Act lets them have access to those records so they know what's going on in government. So the heart of the Tennessee Public Records Act is in Tennessee Code Annotated 10503. This provides that all public records shall, during business hours, be open to inspection to any Tennessee citizen unless otherwise provided by state law. We attorneys like to say this creates a presumption of openness. In Tennessee, all public records are presumed open to Tennessee citizens unless a state law specifically provides otherwise. That's the general rule under the Tennessee Public Records Act. I should note the Act is interpreted very broadly. The Act itself directs courts to interpret the provisions of the TPRA broadly so as to give fullest possible public access to public records. As stated by the Supreme Court back in 2004, the Public Records Act expresses a clear legislative mandate favoring the disclosure of public records. Unless there is an express exemption within the law, disclosure is required, even in the face of serious countervailing considerations. And these do come up. You may have a situation where someone has requested sensitive records or records containing information that you think the public doesn't need to know. However, if there's not a state law specifically making that record or that information confidential, you are required to disclose that information. So who is subject to the Tennessee Public Records Act? Well, all state, county, and municipal records are open under the Public Records Act, and all branches of government and subdivisions of government are subject to the Public Records Act. So the County Board of Equalization, as a subset of county government, is subject to the Public Records Act. That's why we're going over all these, because you might receive a public records request and you need to know how to handle that and how to respond in accordance with the law. I should note there are certain private entities that can be subject to the Public Records Act if they're performing an essential government function. An obvious example of this would be a privatized correctional facility. Courts have held that since harboring inmates and prisoners is an essential government function, that even if a private company is doing that, they should also be subject to the requirements of the Public Records Act. So who can access public records under the Public Records Act? Public Records Act provides that public records are open for personal inspection by any citizen of Tennessee. So the Public Records Act really provides Tennessee citizens the right to access public records. It also provides that a government entity may require presentation of a photo ID that includes the person's address, or they can require an alternative acceptable form of ID. Most government entities in the state have in their public records policy that they require a Tennessee driver's license. But some government entities have noticed there are situations where they might accept an alternative form of ID. A lot of public universities are now accepting student ID, even though the student may originally be from another state. If they're here for school and residing where that college is, they'll accept that. Some utilities accept a utility bill. Some counties are accepting proof of property ownership. If someone lives in the county, they're paying property taxes in the county, which is why they might be before your board. Maybe because of that, they're going to allow them to have access to public records. Requiring proof of citizenship is completely discretionary. There's nothing that prohibits a government entity from providing records to someone that's out of state. But this should be in your local public records policy. So if you have a question about this, please refer to your local public records policy. So what is a public record? A public record in Tennessee is a record that is either made or received, one, pursuant to law or ordinance, or in connection with the transaction of official government business. The definition specifically excludes the device or equipment that made the public record. So while citizens are entitled to access records created by computers or cell phones or other devices, they're not allowed access to that specific device, but they are entitled to the records created by that device. Now I should note, based on the definition, whether a record is created on a government device or a personal device, sent through a government email or a Hotmail or personal email account like Gmail, that does not matter. You have to look at the record and the purpose for which it was created. I can send a text message from my personal cell phone that I personally pay for. If it's related to the transaction of official government business, my work as a government employee, then I am creating a public record on my personal device. Likewise, I could send an email from my comptroller issued email account that has nothing to do with my work as a government official. And that would not be a public record even though it was created on a government email system. Just remember, you have to look at the purpose for which the record was created. The most common public records we come across are usually government correspondence, emails, texts, tweets, Facebook posts. We're starting to see a lot of requests for video recordings, surveillance, government personnel records, travel and leave information, meeting agenda and minutes. This is really applicable to members of the county board. People want to know the decisions you're making, how you're making those decisions. They want to know what you're deciding. So a lot of people like to request agendas and meeting minutes of governing bodies, which would include the county board. Contract, bid documents, budget records, financial records, these are all records that citizens tend to request under the Public Records Act. Now let's talk about some records specific to property assessors. The assessment roll. Under Tennessee Code Annotated 675508, prior to May 20th of each year, the assessor shall note upon the assessor's records the current classification and assessed valuation of all taxable property within the assessor's jurisdiction. The statute specifically says this record of all taxable property must be available for public inspection at the assessor's office during normal business hours. So this record created by the Property Assessment Office is already going to be public record under the definition of public record. But this statute takes it a step further and clarifies and specifies that it is open to public inspection during normal business hours. The statute also provides that the assessor must provide notice of when and where the records may be inspected, and has to put that in a newspaper general circulation. Also, assessment notices. Under 675508, at least 10 calendar days before the local Board of Equalization commences its annual session, the assessor shall notify each taxpayer of any change in the classification or assessed valuation of the taxpayer's property, and the notification shall show the previous year's assessment and classification and the current year's assessment and classification. Now this has a retention provision in it. So this statute provides that you have to keep a copy of this notice for not less than 2 years. So be aware of that. Records retention is also another issue that comes up. With counties, it's generally regulated by guidelines promulgated by the County Technical Service Assistance Service, CTAS. But here you have a specific statute that directs how long you have to keep these assessment notices. So be sure you're doing that. We also have property record cards. 675804 specifies certain information that has to be in property record cards. And this would be open public record that any citizen can request under the Public Records Act. It has things like the description of the property, the name of the true owner or owners, the value of the land, classification, subclassification, the actual assessment, and other information that may be required by the State Board of Equalization. So as I mentioned before, public records in Tennessee are presumed open to inspection to Tennessee citizens unless otherwise provided by state law. So we call these exceptions. These are statutes that make certain records confidential because they're an exception to the general presumption that the records are open and public. Our office was asked back in 2017 to compile a report of all of these statutory exceptions. And at that time, we found about 538 statutory exceptions that make certain records or information confidential. At this time, we're up to almost 600 of those exceptions. Most of these exceptions, the general ones, are in 1075504. However, about 500 or so of those are scattered throughout the Tennessee Code. And there's some that deal specifically with property assessments, so we'll get into those. I should note that state law, for purposes of the Public Records Act, doesn't just include Tennessee statutes. It also includes rules of court, administrative rules, common law, and federal laws. So there are other laws such as court orders or rules of court that can apply to make certain records confidential. We have the statutory report available on our website, and we've put it in a searchable database. So if you're ever in a situation where you wonder if you can release a record or if you can release certain information, go to our website, pull up this database, and you can there's a little search bar on the top right, and you can put a search term in and it'll pull up all exceptions that use that term. It's really handy. So common exceptions we see, certain government employee personnel information is confidential. Personally identifying information is confidential. This isn't name, phone number, address, things that you might commonly associate with the term personally identifying information. This is more like driver's license number, social security number, taxpayer ID number, but it universally applies. Pretty much any public record you disclose, you always have to redact personally identifying information. So be aware of that one. Security surveillance of government buildings, certain investigatory law enforcement files. Certain records contain juvenile information or information related to the Department of Children's Services. Medical information is protected by federal law under HIPAA. Student information is protected also by federal law under FERPA. There are a lot of statutes that make medical information confidential. It's almost universally confidential, so if by some reason the County Board of Equalization comes across someone's medical information, that's likely to be confidential. I don't know why you'd have it, but just in case. Certain proprietary information and trade secrets are also made confidential. So some of these exceptions that apply directly to you as part of the county board, one is 675303D. This provides that assessors have the power to examine and obtain information from persons regarding assessment of taxable property in their jurisdiction. Any information the assessor collects pursuant to this statute is confidential and can only be disclosed to the taxpayer or the taxpayer's designee, individuals designated by a judge, or government officials responsible for administration or collection of taxes. So you as members of the board would probably be entitled to access this confidential information, but a citizen couldn't come in and make a public records request and obtain that same information. It would really be accessible to the property assessor, the county board, and the individuals responsible for assessing those property taxes. Another one that is similar relates to the assessment of tangible personal property. So apart from the taxpayer's annual reporting schedule filed with the assessor, information required to be filed or submitted by a taxpayer with regard to the assessment of tangible personal property is confidential. So a lot of information and records submitted about It could be a business that has a lot of airplanes, something of that nature. Or maybe it's just assessing how many desks and chairs they have. If it's information submitted regarding the taxing of that tangible personal property, it's confidential. And again, it can only be disclosed to certain individuals that are responsible for assessing those taxes. So that's the Tennessee Public Records Act in a nutshell. This is the basic analysis we kind of run through and that we provide to a lot of government officials when they get a public records request. They look first, is it a Tennessee citizen? Is Tennessee citizenship required? If so, what kind of proof of citizenship is acceptable? Is it a government entity or functional equivalent? If a request is submitted to the county board, that's easy. You are part of government and you are subject to the Public Records Act. Is it a public record? Is it a record related to the transaction of official government business, or was it an email you sent to a fellow board member about getting lunch after the meeting? That wouldn't be a public record because it's completely unrelated to the transaction of official government business. Do responsive records exist? A lot of times we see individuals that believe government has certain records when in fact they don't. And that's fine. If a government entity doesn't have the records, then they can't produce them, and they can deny a request on the basis that they don't have responsive records. Now, I should note there's a distinction between records and information. Under the Public Records Act, a citizen can request public records that currently exist. They cannot generally request information. A lot of people have heard of the Freedom of Information Act. So they believe under FOIA, they can just request general information from a government entity. That's not the case. FOIA, I should note, doesn't apply to any state or local government. It only applies to federal agencies. But under the Public Records Act, they can only request current public records that exist. So for example, a citizen could come in and make a request to the county board and say, I want to know how many, property tax appeals you heard last week. I want to know how many deal with this half of the county. If you don't have a record with that information, a government entity is not required to sort through and compile that information for a requester. They can say, we don't have a record with that information, that record doesn't exist, and they can deny the request on that basis. Also, the request has to sufficiently describe the record so they can be identified. Sometimes we come across very vague and broad records requests. If you are unable to identify responsive records based on the request, then you can deny the request on that basis as well. Now, this doesn't mean you can deny a request simply because it's large, and it might produce a large amount of records. A citizen could come into your office and request every record related to any tax assessments that you did last year. That would produce a lot of records. That doesn't make it an invalid request, it just makes it a large request, and you would have to comply with that. If you run into that situation, we would recommend segmenting out the request, going through the records, redacting any confidential information, and just making those records available to the citizen as they're redacted and they become available. Then lastly, does an exception apply? Does an exception make the entire record or just information within the record confidential? Then is there an exception to that exception? A great example of this would be the taxation of tangible personal property I mentioned earlier. You may have certain records that have that information in it. You would need to redact those records. But of course, there's an exception to that exception. What if it's the judicial officer requesting those records? They're probably entitled to receive those records. So you have to see it. Even if an exception makes a record confidential, there may still be certain individuals that can access that record. So I mentioned this public records policy. Pursuant to 107-503G, every governmental entity subject to the Public Records Act has to have a public records policy. This policy has to have the process for making requests, including any required forms, process for responding to requests, a statement of any fees and billing and payment procedures, and contact information for the Public Records Request Coordinator. All government entities subject to the Public Records Act had to have a public records policy by, I believe, July of 2017. We released a model policy in January of 2017, And we believe most government entities have these policies in place. Your county board may not have its own separate public records policy. In that case, you might be under the umbrella of a county-wide policy. So you might need to reference the county general policy for public records requests. That doesn't mean a county board couldn't create its own public records policy if it wanted to. It's really within the discretion of each board. But you need to have this policy, and really having this public records request coordinator is a great thing. If you don't have your own policy and you're subject to a county policy, the public records request coordinator is the person that's responsible for receiving requests, routing them to the appropriate records custodian, and they make sure requests are handled in accordance with the Public Records Act. The PRRC, as we call them, they're very familiar with the requirements of the Public Records Act. So if you get an odd request, you might want to reach out to the PRRC for your county and get their advice on the request. So responding to requests. Under the Public Records Act, the requirement is promptness. A government entity is required to promptly provide access to public records. If it's not practicable to promptly provide access, then within 7 business days, the government entity has to make the information available, deny the request in writing with the basis for denial. So maybe someone requested records related to tangible personal property. You could deny that request, but you would need to put that statute in there as the basis for denial. Or if it's possible to redact that information and provide access to the rest of the record, that is what the Tennessee Public Records Act requires. So if you can redact, you would just need to redact that information. Lastly, if it's not practicable to promptly make the records available within 7 business days, you may need to furnish the requester the time reasonably necessary to produce the records. This happens often with a large request. If it's not an easy record you can just provide to them promptly, maybe it'll take you a week to go through the records, redact the records, then you would need to advise the requester within 7 business days of that time necessary to produce the records. Failure to respond in accordance with the statute, one of these 3 methods, is a denial of the request. And that gives a citizen the right to petition for access in your local chancery court. So if you fail to do one of these 3 things, it does enable that citizen to sue you. So we always recommend taking one of these actions. That's another reason you might want to contact your public records request coordinator if you get a request, because they're aware of this and they're used to responding to requests and they can assist you with that process. As I mentioned before, our schedule of reasonable charges sets forth reasonable charges for copies. I should mention you can only charge a requester if they want copies of a public record. If they only want to come in and look at public records and not take a copy home with them, you cannot charge them anything related to that request. If you are going to charge them in accordance with our schedule, you can charge for the copies and the labor involved. If you have to retrieve the records, review the records, redact the records, you can charge for that labor. Generally, it's 15 cents per page for copies, 50 cents if it's a color copy. You do need to use the lowest possible labor you can. Whoever's capable of responding to the request at the lowest hourly rate, try to use that person. There is a 1-hour labor threshold, so if it doesn't take you more than an hour to respond to a request, then you can't charge labor for under an hour, so just keep that in mind. As I mentioned before, you can charge for the redaction of copies, as long as they want a copy. If they only want to inspect, you cannot charge. Public Records Act requires that you provide an estimate of costs. So if you are going to charge someone for copies of records, and you know it's going to take some time, when you're sending them the response, letting them know the reasonable time necessary, you also want to send them an estimate of the charges. And you can require payment before you start copying the records. We encourage to get payment up front. So there's some penalties that were recently added to the Public Records Act. If a requester fails to inspect records or a requester fails to pay for copies, just be aware of these. If someone makes 2 or more requests within a 6-month period and they fail within 15 days to come in and inspect those records, then you're not obligated to fulfill more public records requests from that person for 6 months, unless the failure to view was for good cause. Maybe they were out of town because their grandmother was sick or something. Maybe that's good cause and you don't apply that provision. The failure to pay for copies provision is a little more straightforward. If a government entity provided the estimate of costs that you're required to provide, and the requester agreed to pay those costs, and the requester fails to pay for those copies after they're produced, then you don't have to fulfill any more public records requests until they pay for the copies they said they'd pay for. Because of this new provision, we encourage government entities to get something in writing showing that the requester agreed to pay for the copies. That way, when they don't pay for the copies, you can rely on that to deny future requests. You may want to have them sign the estimate, or you could just, if you're emailing the person, you might have an email that says they agreed to pay for the copies. So let's switch to the Tennessee Open Meetings Act. Tennessee Open Meetings Act is contained in Tennessee Code Annotated 844-101. The formation of public policy and decisions is public business and should not be conducted in secret. That's the general premise of the Open Meetings Act. Making public decisions is public business. As with the Public Records Act, it's construed broadly in favor of the public. Now, it only provides the public the right to attend, not to participate. So if you're having a public meeting of the county board, anyone can come and be there, but that does not enable them the right to speak. If a person comes in and they are disruptive or unruly, you can have them removed from the meeting. So just keep that in mind. So the Tennessee Open Meetings Act applies to any meeting of a governing body. We have a quick video that demonstrates this and the public's right to attend. As I should note, the public, when they're attending, also has the right to record your meeting if they'd like to do so. This video is a great example of that.
Mr. Williams, how are you today?
The value of my house is entirely too high.
Stop! Ms. Williams, we do not allow video recording during our meetings.
We understood this was an open meeting and that we are allowed to video.
We need your sister to step out in the hall. We don't allow video recording during our meeting.
So, as you can see there, that governing body improperly told that individual they could not record the public meeting. As long as that individual is not being unduly disruptive, they can sit there and record the meeting. So just keep that in mind. So what is a meeting of a governing body to which the requirements of the Open Meetings Act would apply? The term meeting and the term governing body are defined in Tennessee Code Annotated 844-102. The definitions aren't exactly clear, so the courts have gone through and helped us interpret what is a meeting of a governing body. Basically, a meeting of a governing body occurs when you have two or more members of a public body, such as the county board, that discuss or deliberate matters a quorum of that body would need to vote upon. So, when you're a member of a governing body, outside of a public meeting, you don't want to discuss matters that a quorum of that governing body would need to vote upon. We have another great video that's a good example of things that maybe you shouldn't discuss outside of an open public meeting.
Hey guys, I know we're not in our meeting yet, but I thought I'd let you know that my niece Amber, she's got an appointment with the board today. You all know her.
Yeah, she's the one with 3 children.
Yeah, that's her.
I saw her at the grocery last night. She's real sweet.
Yeah, she is.
So what seems to be the problem? Why is she coming in?
Well, it's her house. It's in bad shape. It's nowhere near the amount that they have it assessed for. Guys, we really got to do something.
Sure, I think we can do something about that.
Yeah.
Yeah.
So as you can see there, these members of the governing body were probably discussing things that they should have only discussed in an open public meeting. And that was likely a violation of the Tennessee Open Meetings Act. The general rule is 2 or more members of a governing body should not discuss or deliberate matters that the public body as a whole would need to vote upon. The courts have looked at what to discuss or deliberate means and have decided this means to weigh arguments for or against a proposed course of action. So members of a governing body might be able to receive information or share information, but once they start engaging in that deliberation, then you're likely to have a meeting of a governing body. And if that deliberation occurs outside of a public meeting where you have proper notice, then you're going to have a violation of the Open Meetings Act. So let's say you do have a meeting of a governing body. You have 2 or more members that are together discussing or deliberating public business that the board as a whole will need to vote upon. What are the requirements? Well, the meeting must be open to the public. You have to provide adequate public notice of the meeting. You have to have meeting minutes. And under the Open Meetings Act, all that's required to be in those minutes are the persons present, the motions, proposals, and resolutions offered, and the results of any votes. Also, any votes must be by public vote, public ballot, or by public roll call at a meeting of a governing body. I should mention the Act itself does not require an extensive amount of information in meeting minutes, but lots of governing bodies like to include more information as a reference. That way, if they can't remember what they decided 6 months ago, they can go back. Maybe the board wants to see how they landed on a position last year when they had a similar issue. So we encourage governing bodies to include more in their meeting minutes so they have it there as a reference. So what is adequate public notice? We get this question a lot. Members of governing bodies often contact us. Is 2 weeks okay? Is 1 week okay? What is adequate public notice? Well, it's not defined in the Open Meetings Act. It really depends on the totality of the circumstances. For a regular meeting, the Supreme Court has determined that notice is adequate if it gives interested citizens a reasonable opportunity to exercise their right to attend. It's not the clearest definition, but basically you have to see, is the notice you provided in your community adequate so that people that are interested in the meeting are aware of it and can attend? And it's going to be different depending on what type of town or city you're in. There's some towns where they always post notice, maybe in the courthouse, and everyone's aware of that, so that's usually okay. There's other towns where maybe no one would see the notice there, and that would not be sufficient. So it really depends on the totality of circumstances. I should note, for specially called meetings, there are heightened notice provisions. For a specially called meeting, the notice has to include the content in the notice, and it has to reasonably describe any proposed actions or decisions that are being made. It doesn't specifically require an agenda be included as part of the notice, but a lot of governing bodies, when they have a specially called meeting, will post the agenda to satisfy that requirement. I should note that the word agenda doesn't appear in the Open Meetings Act at all. Governing bodies are not required by the Open Meetings Act to have an agenda or to publicly post an agenda. Now, for County Boards of Equalization, there are some very specific notice requirements. So you generally don't have to worry about whether your notice is adequate, because if you're doing it in accordance with state law, it's going to be adequate. So for County Boards of Equalization, you have to have notice in a newspaper or general circulation at least 10 days before the start of the annual session. The county assessor's office has to publish notice that has the date and time the assessment records may be viewed, the date the County Board of Equalization will begin, the last day they'll accept appeals, and a warning in the notice that says failure to appeal may result in the assessment becoming final. So you have to have all the specific information in the notice for your County Board of Equalization. And it even goes a step further to require that the notice in the newspaper has to set forth in prominent borders with a width of not less than 2 regular columns of the newspaper and a depth of at least 4 inches. Your county can also post notice on their website, so be aware of that. So we get a lot of questions about executive sessions. Maybe the board needs to meet with an attorney. You have informational sessions, workshops. Certain hospital boards have statutory authority to have executive sessions. School safety planning committees can meet in private. Generally, citizens are not fans of executive sessions when boards meet in private. Sometimes it looks suspicious, but it is allowed. But even if your governing body, your board, is an executive session, you still cannot discuss or deliberate matters that the board as a whole would need to vote upon. You can receive information from your attorney, you can receive information, provide information, but you still can't engage in that discussion or deliberation. That always needs to occur at a public meeting in the public. So be aware of that. So what happens if your board violates the Open Meetings Act? State law provides that any actions taken in violation of the Open Meetings Act are void. So sometimes if a citizen doesn't like the action that was taken by a governing body, they have a judicial remedy in the statute, 844-105, 844-106. And they can take the governing body to court and have that action invalidated. Courts have very broad jurisdiction when it comes to remedies of violations of the Open Meetings Act. They will issue an injunction. They'll require the governing body to submit meeting minutes, agendas, to make sure the governing body is still complying with the law. But they can impose whatever other relief they think is necessary to remedy the violation. Generally, you just want to make sure you're not discussing or deliberating matters with other board members outside of an open public meeting. We can't stress this enough, for one, because it is a violation of the Open Meetings Act, but also it creates an appearance of impropriety, and it might affect the public trust in your board and what you're doing. So you really want to make sure everything is done publicly in the public eye so people can trust the decisions you're making when you're meeting. Here's our contact information. Rachel Buckley is an assistant general counsel in our office. She also handles public records and open meetings issues. There's our phone number, our email address, and our web address. Thank you for your time.
Hello, and once again, my name is Robin Pope, and I currently serve as the Executive Deputy Secretary with Tennessee State Board of Equalization. Now, I have a couple of special considerations this year to bring to you. Specifically, we're going to talk about how to hold telephonic or remote virtual meetings for the County Board of Equalization. We are also going to talk about applying equalization ratios or appraisal ratios, what they are, where you can find them, and when you should apply them. It's important to remember that taxpayers always have an ability to appear telephonically before the County Board of Equalization. This is true every year, regardless of the circumstances. It's up to your county to decide if allowing taxpayers to appeal telephonically is the right decision for you. However, if you're going to allow it, you should also probably allow it to be an equal opportunity for every taxpayer appearing before you. For instance, a taxpayer may have a variety of reasons for appearing telephonically. It may be they live out of state. It may be they're currently on a job assignment that takes them outside the county or country. It may be that they are unable to physically attend due to some sort of physical or ailment they have. So it's important that you allow this option equally to any taxpayer who requests it if it is the right option for you and your county. Next, we need to address some special considerations having to do with the coronavirus and other public health emergencies that you may experience this year. If a public emergency requires a governing body to meet virtually or remotely, you should always follow the relevant guidance from the governor of the state of Tennessee, as well as any of your local governing officials. If you have questions or concerns about how to comply with your open meetings and open records requirements, make sure you contact the Office of Open Records Counsel with the Comptroller of the Treasury. It's important to remember that unless specifically provided for, the open meetings and open records requirements are still in effect. On March 20th, 2020, Governor Lee signed Executive Order Number 16, which temporarily suspends some of the requirements of Tennessee's Open Meeting Act to allow governing bodies to meet virtually or telephonically by electronic means. However, this order is currently set to expire on May 18th, 2020. County boards, however, do not meet until June 1st. As of this taping, it is believed that this order may be extended or may not be extended depending on what is required to protect public health and safety. If the order gets extended or the board otherwise needs to only have hearings virtually this year, the Office of Open Records Counsel recommends you make a determination on the record, that means during your proceedings, that meeting electronically is necessary to protect the public health, safety, and welfare. You must include the determination in the meeting minutes and include this information in the notice of the meeting to the extent possible, which basically means you still need to notice that the county board will meet And you should notice, if possible, that you will be meeting virtually and how people can attend virtually. You should always encourage public participation in your open meetings, although that encouragement may look a little bit differently if you're meeting virtually. You should do your best efforts to provide the public with live electronic access to the meeting and include instructions as to how the public may electronically access that meeting. It's important just to use the tools available to you. This may be simply something as easy as a conference line of a dial-in number, or you could be more sophisticated. Depends on what solution is right for you and your county and your board. There's a variety of resources out there, including online sort of virtual platforms like Skype, Zoom meetings, Facebook Live. If you're able to provide the public with, if you are not able to provide the public with participation, you must make a clear audio or video recording of the meeting and make that recording publicly available within 48 hours of the meeting. As I said before, it's still important that you notice the public meeting. Notice the time, the place, and the date of the meeting, as well as if a physical location will be limited. The notice should address if there will not be a physical location for the meeting in order to protect the public health and welfare. Some additional considerations to keep in mind as you move forward with this year's County Board of Equalization meetings. It should be audible to the public at the location specified in the notice of the meeting. Each member participating electronically or otherwise should be able to hear every other member simultaneously and be able to speak to each other during the meeting. Documents to be discussed at the meeting or presented or reviewed should be provided to the members prior to the meeting, to the extent doing so is possible. All votes at the meeting also should be taken by roll call vote. If you're unfamiliar with what a roll call vote is, it's simply where every member is addressed by name and asked what their vote is, instead of a general yay or nay. Notice of the meeting should provide a statement that the meeting will allow members to participate electronically or by other means. And with that, we will switch to appraisal ratios and equalization ratios. For many of you, you may never have heard of what an appraisal ratio is. And for several of you this year, an appraisal ratio won't even be at play. So for those counties that have recently undergone a current value update or a reappraisal, you probably will not have to apply an equalization ratio, but it's important to check with your county assessor to know when your last general reappraisal was. An appraisal ratio represents the change in market value since the last reappraisal. So as we've discussed today, and you will probably discuss with the Division of Property Assessments, a reappraisal is where all properties in the county are appraised as of market value. Their values are updated to represent the current market value of the property within the county. As time moves on, oftentimes property values continue to increase. However, for property tax purposes, values are locked as of the last reappraisals and do not increase. So although you may be able to sell your house for more than you were previously, your taxed value is still going to be that of your last reappraisal. So often this means in a reappraisal year, your equalization ratio is 1. It means all your properties are currently at the same value as market value as if you were to sell it on the open market. This is also true in the year following a reappraisal, in current value update years, as well as a year following a current value update. If you're looking for where you can find your county's equalization ratio or appraisal ratio, the answer is the State Board. The State Board of Equalization approves these ratios on an annual basis, and we keep a record of the appraisal ratios on our website. The appraisal ratios are approved by the board after being calculated by the Division of Property Assessments. The Division of Property Assessments works with the county assessor to find out what current sales in the market have been and determine how far market values have changed since your last reappraisal. This process is done on every 2 years outside of a reappraisal or current value update year. So if you've recently had a reappraisal, or you're less than 1 year away from your most recent reappraisal, you will have a equalization ratio of 1. So most importantly for you as the county board members is, when do you apply this? Why does this matter for you? When will I have to interact with an equalization ratio? And again, it's only for those counties that are more than a year out from their last recent reappraisal. You only apply an equalization ratio when you, as the County Board of Equalization, have found the current market value of the property under appeal. So as the County Board of Equalization, you may or may not find the current market value of a property. However, you also may make a decision which has an effect on property values without finding that current market value. I know that can be kind of a big topic, so we have some examples. An example would be if you're correcting an error in a property's description. In which case, if for instance, if the taxpayer appeals to say that I don't have a detached garage, it was torn down, and is appealing in order to get that record corrected, and you and the county board agree with him. You are not necessarily finding the current market value of the property, but you are finding that there is an error in that description. The assessor can then work to update that property record card, which will have an effect on that taxpayer's value. However, the rest of the value of the property will be valued as of the last reappraisal. So remember, your last reappraisal will be almost 2 years ago. So that's not the current market value. It's the same value as everyone else in the county who has not appealed. There also are some times where you might find an added form of depreciation exists, or a specific factor which may have an effect on value but is different and separate from a finding of current market value. So why do we apply this ratio? Why is finding the current market value such an important thing to do before you apply an equalization ratio? And it's because that partly it's appraisal theory. It has to do with how we appraise properties in Tennessee. It's also key in the name, equalization. This ratio equalizes current market value properties with properties which were not appealed. Essentially what it means is that if a property is presented with a current market value, it's reduced in order to match it with properties which have not appealed, properties whose values have not increased over time and who have not shown a current market value. Another way of saying it is it pretty much accounts for factors such as inflation and changes in market value over time. If you would like any more resources on open meetings requirements or equalization ratios as well as appraisal ratios, you can find them at our website at www.comptroller.tn.gov. Thank you.
Hello, I'm Emily Bennett. I'm Senior Tax Counsel with the State Board of Equalization, and I'm here today to talk to everyone about the purpose and composition of County Boards of Equalization. It's going to be kind of going over the nuts and bolts of what the County Board of Equalization is. So a little roadmap for today of what we're going to talk about. First, I'm going to explain what equalization means. Then I'm going to go over levels of appeal for property tax issues. We're going to talk about the county board and its purpose. Going to go over the formation and makeup of county boards of equalization. Talk about alternates serving on the County Board of Equalization, county board officers, quorum, and records. We're going to discuss compensation and training of county board members. I'm going to go over the oath of office. We're going to go over how long the county board stays in session. We're going to go over all the duties of the county board members, and then we're going to talk a little bit about appearance of impropriety and conflicts of interest. So the first question that might come into your mind is, what does equalization mean? I'm on the County Board of Equalization. What does that mean? It's the process by which an appropriate governmental body ensures all properties in a jurisdiction have been assessed fairly by appraising the properties at fair market value, including application of the correct assessment percentage based on classification as required by law. You are the appropriate the governmental body. That's the County Board of Equalization. What we want to do, we want to make sure properties are assessed fairly and at market value, no more, no less. This is what really unifies the assessor, the County Board of Equalization, and the State Board of Equalization. We're all trying to get to the right value. We all have kind of the same goal with what we're doing with our function. So we have here the levels of appeal. The first thing on the slide is called informal review. We're going to talk a little bit more about that in a few minutes. It's not really a formal level of appeal. The first formal level of appeal is at the County Board of Equalization. Then you have the State Board of Equalization, where there are 2 levels of appeal. You can go before an administrative law judge, and then the second level would be the Assessment Appeals Commission. Next would be Chancery Court, and you can move forward from there to the Tennessee Court of Appeals, and then even all the way up to the Tennessee Supreme Court. So this slide is really just a visual representation of levels of formality. I think it's a good representation. So if we look here, you're going to see the moccasins down towards the lower end, and that's kind of your informal review process. That's what the assessors do before an appeal or a complaint comes to the county board. The county board is really your work boots. That's your first level of appeal, as I've already mentioned, and it's a pretty informal proceeding. So then you're going to move up. If you move up to the administrative law judge, that's kind of your suede boots there, your chukkas. It's still informal, but there's a little bit more formality than you would have before your county board. So as you keep moving up, it's going to get a little bit more formal. You've got the loafers. That's going to be the Assessment Appeals Commission. That's getting to be a little bit more like going to court. And you can go all the way up there to the opera pumps, which that might be the Supreme Court. And I think the point is, the further you move down that scale in terms of formality, the more adversarial the process becomes, the more technical it becomes. The parties are going to be spending a lot of money. It's better when you can to try to solve problems at the lower end of that spectrum. Appeals that move past that informal stage are going to be a drain on resources, both financial and time, for all parties involved. So, informal review. This is something that some assessors have established that helps to decrease the volume of appeals and complaints that are officially filed to the County Board of Equalization. It's a process where a taxpayer can make an appointment with the assessor's office and discuss their property tax concerns in an informal environment. The counties have different ways of handling this process. So, for example, Davidson County and Shelby County, they have information available on their website. You can actually go directly on their website and file your request for an informal review. Other methods for making that request might be calling the assessor's office to make an appointment, or you might just go visit in person and ask that you get an appointment to discuss your property tax concerns with someone. It's really, the process is going to depend on the resources available for the particular county. Parties are going to be given ample notice of the result of that informal review. As the slide says, the assessor is going to inform the taxpayer in writing of the taxpayer's right to appeal to the County Board of Equalization if dissatisfied with the outcome of the informal review. An informal review has to conclude at least 10 days prior to the adjournment of the County Board of Equalization. So, what is the purpose? What are we here for? What do we do? You're here to provide a fair and efficient process where taxpayers and owners of property may receive equalization in their property's valuation. This is the first level of appeal. The County Board of Equalization is a neutral party between the taxpayer and the assessor of property. And in addition to these stated duties, we need to remember that every party wants to have their day in court. They want to feel heard, they want to be given an opportunity to make their case, and probably most importantly, they want to be treated with fairness and respect. And I think it's important to remember that property taxes are the largest source of revenue for local governments, and it's essential that we have a properly functioning property tax system. The county board is a vital step in this process. This is the first formal level of appeal, and it may be the very first time that a property owner is interacting with a government entity, that they're expressing disagreement, and that they're asking for help. And so we just want to keep in mind that treat them with fairness and respect and try to get to the right or fair value. The typical makeup for a county board of equalization is going to be 5 taxpayers, and they're appointed to serve for a period of 2 years. This is typically done in April of years ending in even numbers. If the county legislative body fails to elect or appoint the members of the county board, the mayor can do so, and the mayor also fills vacancies on the board as they occur. I just want to note there are some exceptions to this typical makeup, but that's going to be the usual number of members for most counties. Also, a general rule, government officials and employees are ineligible to serve on the County Board of Equalization. This prohibition does not apply to people who receive only compensation in lieu of expenses or a per diem payment. Again, there's, like every rule, there's some exceptions to that, but that is the general rule. You can always contact our office with any specific questions you have about whether or not a person is eligible to serve on the County Board of Equalization. Another thing we want to talk about is alternates. The county legislative body can appoint alternates to serve on the County Board of Equalization. In general, it's a good idea to appoint some alternates. At the State Board of Equalization, we use alternates at the Assessment Appeals Commission. It can be difficult to coordinate schedules, or things may come up. A member may be disqualified from serving, or have an illness in the family or some other event that arises and they can't be there on a particular day. Need to keep in mind, alternates have to take the same oaths. They have to be sworn in. They have to be trained just like regular members, but their actions have the same effect as those of regular members. Each county board has to elect a chair and a secretary. You want to elect a chair because somebody needs to run the meeting. You want to elect a secretary because someone needs to take notes. Another duty is to keep a daily record of the transactions and sign that record. You have to have a quorum to conduct business. So in my example, when I discussed the typical makeup of a county board, I said there's usually 5 members. So to conduct business on a given day, you've got to have at least 3 of those members present. We get questions sometimes about audio recordings at hearings. It's perfectly fine. Some counties have a very sophisticated system for recording the meetings. And some counties, the assessor records the meeting. And some counties, the secretary's notes are the record of the meeting. The question we get is, how do we sign that record if it's recorded? And we would just suggest at the end of the recording, the chair can say, this is a record of the meeting on, and specify the date, and that's fine. Another option would be to transfer the recording to a disc. You could put the disc in a case, and the chair can sign the case and date the case, and that will fulfill the requirement. It doesn't have to be super formal, don't have to overthink it. Those things will work. Compensation and training. So good news is board members get paid. The county legislative body adopts a resolution to establish the compensation of the members and the chairperson. Training, this is why we're here. The county mayor has to require the board members to complete annual continuing education and training. It's a minimum of at least 4 hours of training for board members to complete annually. County Board of Equalization members before discharging duties of the office, they have to sign an oath, they have to be sworn in. It's usually going to be the county mayor that swears in those county board members. We do get questions from time to time, what if the county mayor can't be there? Any other official that's authorized to administer oaths can administer that oath. The oath is going to be signed and it's going to be filed with the county clerk. Not going to read that to you, but basically we're going to hear these appeals and we're going to be impartial and we're going to be fair and we're going to do our job to the best of our ability. So how long are we in session? Well, we're going to be in session as long as the statute says we have to be in session, and it's based on population. So it's 6 days if the population is 10,000 or less. It's 10 days if it's between 10,000 and 20,000. It's 15 days if it's over 20,000 and under 35,000. And it's for more than 15 days, but no more than 30 days if the population is over 35,000. Now, does this mean that you have to meet for all of those days if you don't have enough appeals? No. You have to be available for as long as necessary to conclude the business of the board. So that might be 1 day, but you're going to go in and you're going to have your organizational meeting and you're going to elect your chair and your secretary. And you know, the main takeaway there is don't limit taxpayer access to the board. Also want to mention, normally you convene on June 1st. If June 1st is on a Saturday this year, you're going to convene on Monday, June 3rd, next business day. Well, you might ask, what if that's not enough time? There's something going on. It's a reappraisal year. We have too many appeals. There's some other issue in the county and we have too many people wanting to be heard and we can't do it in 6 days. The county mayor can extend the session of the county board or call a special session of the county board. This can occur for these reasons as well. There might be some errors. There might be an ouster of an assessor. You may have assessments that are in non-compliance with statutory or constitutional provisions. So here I'm just going to go over the duties of the board, and these are laid out in statute. So the board is going to hear complaints or appeals from taxpayers, carefully examine, compare, and equalize county assessments, assure that all taxable properties are included on assessment list, eliminate from assessment lists such property as is lawfully exempt from taxation, hear complaints of taxpayers that feel the assessments of their property to be excessive or incorrect, correct errors arising from clerical or other obvious mistakes that may be brought to the attention of the board, decrease the assessments of properties the board determines have been excessively assessed, increase the assessments of such properties as the board determines have been underassessed, provided adequate notice to the taxpayer is given, take necessary steps to assure the assessments of all property in the jurisdiction conform to the laws of the state along with the rules and regulations of the State Board of Equalization. And once we adjourn and we finish and we have performed those duties, we're going to sign a certification of assessments. And again, I'm not going to read it, but you can see some things underlined and highlighted there. We're going to discharge our duties without fear, favor, or affection. Every member is going to sign that certification of assessments. And it's also filed in the office of the county clerk, just like the oath of office. So here's an important topic. This is kind of the last thing I'm going to cover. Conflicts of interest. I'm going to talk about the appearance of impropriety versus conflicts of interest. One thing I did want to point out is in researching this, I found that in 2007, every county was required to adopt ethics policies. And so the county-specific policy would actually apply to board members. If there's a question about whether or not a situation or something is actually a conflict of interest, I would suggest you contact the county assessor. County assessor has people he or she can contact the county attorney, can contact CTAS with questions about this. So what I'm going to do is just give a general overview of definitions of conflict of interest and appearance of impropriety, but I just want everyone to keep in mind that there are specific policies that apply in each county. So I have a couple of different definitions here of appearance of impropriety. I went to Black's Law Dictionary, and it says it is conduct or status that would lead a reasonable person to think that the actor is behaving or will be inclined to behave inappropriately or wrongfully. Wikipedia is kind of similar. It says the appearance of impropriety is a phrase referring to a situation which to a layperson without knowledge of the specific circumstances might seem to raise ethics questions. So in Wikipedia there was an example of what an appearance of impropriety might be, and it's kind of a simple example, but it talked about an employee that may routinely, for some reason, collect money for their employer and they put it in their personal wallet. While they might not really be doing anything wrong and they actually take that money and they give it to their employer like they're supposed to, that can raise suspicions, and it gives the appearance of impropriety, even if they might not really be doing anything wrong. Conflict of interest. Black's Law Dictionary says a conflict of interest is a real or seeming incompatibility between one's private interest and one's public or fiduciary duties. Wikipedia says a conflict of interest is a set of circumstances that creates a risk that professional judgment or actions regarding a primary interest will be unduly influenced by a secondary interest. So a primary interest, that's going to be your duty as a member of the county board. A secondary interest is going to be a personal or financial interest of some sort. And that's how we define those. But again, keep in mind specific situations you need to talk to your county assessor. Wanted to talk about disclosure of conflicts of interest. Recommend always disclosing a conflict of interest. If it's disclosed, the effects can be mitigated. You know, conflict of interest, you might have to recuse yourself from a hearing. Again, whether that's required in your county, I can't answer that. A board member may even decide to recuse when there's not a conflict of interest that would violate a specific policy, but just to avoid the appearance of impropriety. And on the next slide, I'm going to show you a little video that kind of demonstrates what I'm talking about here with the conflict of interest versus the appearance of impropriety.
Good morning, Mr. George. How are you doing today?
Tony, I need to excuse myself from this board meeting. Mr. George and I are business partners.
Oh, of course. Thank you, Lou. As she's stepping out, we'll just get ready to conduct our business with Mr. George.
So what we just saw in the video is one of the board members got up. She announced that the gentleman that was coming in was her business partner. She disclosed the relationship. We don't know whether that was a conflict of interest that would violate a particular policy, but we know that she either felt that she could not be impartial, or even if she could be impartial, she felt like she wanted to avoid even the appearance of impropriety. We noticed there were 5 board members present at that particular meeting. When she left, that's fine. They can continue to conduct business. We have to remember we have to have a quorum. So one thing we need to keep in mind here is this is where scheduling can be very helpful. When the assessor provides you with a schedule, if you see something on there that might potentially be a conflict of interest, you can let the assessor know. They can arrange for an alternate to be present that day and to be at that hearing so that you aren't in that situation where you have to get up and recuse yourself from being at the hearing. Oops. Finally, the last thing, just to mention, we get questions about this sometimes. The County Board of Equalization does not set the tax rate. The local governing bodies determine what the property tax rates are going to be. The property tax rate determines the amount of taxes that a property owner is going to pay. This is typically set after the county board adjourns for this session. The County Board of Equalization doesn't have any control over the tax rate. So in conclusion, I think we've covered these things. What is equalization? We went over the purpose of the county board, the formation and makeup of the county board, the oaths that the members have to subscribe to, how long you're going to be in session, what your duties are, and then we talked just a little bit about appearance of impropriety and conflicts of interest. Thank you very much.
Hello everyone, my name is Seth May. I'm an attorney with the State Board of Equalization. I'm also the exemption designee for East Tennessee. Today we're going to talk a little bit about the powers and authority of the County Boards of Equalization. We'll talk about the powers and authority of the County Board. We'll also talk about some of the limitations of the County Boards. We'll hit on the role of the County Assessor and a few other odds and ends about the hearings. And finally, we'll watch some exciting video examples. So looking at the powers and authority of the County Board, the primary purpose of the County Board, in most cases, will be to determine the value of the subject properties before the County Board. In so doing, you have the authority to examine any person as a witness. So if the taxpayer brings an appraiser who's done a fee appraisal, you're entitled to ask them your own questions. You're also entitled to examine any evidence brought to the hearing. So you're entitled to examine the fee appraiser's report if it's a written report. You have the option to examine the county assessor. If you have questions about the assessment, about the property record card, you have the authority to examine him and ask him questions. And finally, you have the authority to administer oaths. Administering an oath to a witness does not have to be anything fancy. It can be as simple as, do you swear to tell the truth, the whole truth? And that's all. That person is now under oath. Turning to some of the limitations of the County Board. The County Board should not look at prior year assessments. The County Board also does not have the authority to accept a greenbelt application. So in most cases, the County Board will be looking at the value of a property, but you might be looking at an assessor's determination on a greenbelt application. You can review with the decision the assessor made, but you cannot accept the initial determination, the initial application. And in most cases, the County Board is not going to have the authority to look at an exemption application. There is a little exception when you're looking at property, that government property, but for the most part, any sort of charity, church, or school, that has to go through the State Board, not the County Board. The way an appeal gets to the County Board of Equalization will depend heavily on the county. It will differ between Shelby County, Davidson County, anywhere in between. It might be called a complaint, it might be called an appeal or a petition. What it's called does not necessarily matter. And the way it's filed will also vary by county. Any property owner or taxpayer can file an appeal to the County Board. The lessee who is responsible for property taxes can also file an appeal, or an agent or attorney with the consent of the taxpayer can file an appeal. As far as the logistics of the hearing, the primary concern is that everybody has the opportunity to meaningfully participate. The hearing can be televised, it can be done by telephone, it can be done by Skype or GoToMeeting, any of the other options. As long as everyone can participate, that is A-OK. What is going to be the basis for the appeal? In most cases, you'll be looking at the value of a subject property. You might be looking at the value based on the fact that the condition is not like it's described on the record card, so it's described as new construction when in reality it's quite old. You might be looking at the market value or additions that have been constructed or not constructed. It can be any number of things. The county assessor will be at the hearing with you. The county assessor is a resource. He's not necessarily representing any party. You can ask the county assessor to explain the property record card or why things are classified the way they are. You can ask him about the assessment process, how the assessment was done, anything you feel is appropriate to ask the county assessor. He's there as a resource and you should take advantage of that. So now we're going to move on to one of our exciting video examples. Now, when watching this video, I want you to pay attention to the role of the county board. Try to think of what they're going to be examining, what they're going to be looking for, what is actually being considered at the hearing, and what is the taxpayer looking for.
Mr. and Mrs. Smith, good morning. Thank you for coming in. My name is Tony. This is the rest of our board members. I'm the chairman, and we also have the assessor with us today. So, again, thank you for coming in. And so, how are you doing today?
Not so good. Our taxes keep going up. We bought a 20-acre farm 12 years ago for raising cows, corn, and kids. But we can't keep it if we keep getting notices that it's gone up.
So tell me a little bit about your property. Is the farm on Greenbelt?
Greenbelt, what's Greenbelt?
Greenbelt is when your farm is valued on its use, not on market. A lot of farmers, just like you, use it to keep their taxes lower.
Well, listen, since you don't have it on Greenbelt and you don't know about Greenbelt, go to the assessor's office and fill out an application, and it'll help you on your taxes this year. In the meantime, we'll speak with the assessor, go out to your property, and see if we can find some more reasons to lower it. Does that sound good? And also, you'll get a notice in the mail of the new value changes.
So let's talk about that hearing. What was the taxpayer looking for? They bought that home to raise cows, corns, and kids. And at this hearing, they were looking to get their property tax value lowered. Something that went wrong, first off, Greenbelt. At the time you're meeting, it's almost certainly going to be too late for them to be submitting a new Greenbelt application. So telling a taxpayer to go apply for Greenbelt and it will help lower their taxes for this year is just inaccurate. And that initial application has to be filed with the assessor anyway. It can't be filed by the county board. You also want to look at the burden of proof, and specifically, was there proof presented? In this case, there was no proof. The taxpayer said, we need our property taxes lowered. The county board said, okay, we'll look and see what we can do. That's not the role of the county board. The role of the county board is not to lower property taxes. It's not to help taxpayers, and it's also not to help the county. The role of the county board is going to be to determine the accurate value for the property. So now let's watch another video, and I want you to look at the same things. Look at the role of the county assessor, look at what the taxpayer is looking for, then look at the county board, how they do, how they act, and what decision they make.
So, Mr. Taylor, you've come in to talk about your home value?
Yeah, they say I've got a finished basement. It's not finished at all. You know, it's got concrete floor. You can see the exposed floor joist in it and all. You know, if I ever decide to sell it, I might finish it out, but that's not going to be anytime soon. I've got some pictures if y'all want to see them.
So how do we fix this?
Really simple. We just change it from a finished to an unfinished basement after we review the property.
I say we go with the recommendation of the assessor. Does everyone agree?
Yes.
Mr. Taylor, we're going with the recommendation from the assessor, and once his staff has keyed those changes, you'll receive the new value in the mail.
All right, so what happened in this video? In this video, the taxpayer came in. The taxpayer clearly stated, this is what I think went wrong. This is why I think it should lower the value of my property. He has proof. He hands the proof to the county board. The county board looks over the proof. The county board then examines the assessor. They say, Mr. Assessor, how do we fix this? The assessor makes his recommendation. The board votes on it, and that's done. That's a very nice hearing. You'll notice that they did examine the proof. You've talked about burden of proof elsewhere. They determined that they met the burden of proof. That was a properly done decision. So let's talk a little bit about some of the stranger things you might see. You might see a taxpayer file an appeal to change the value of somebody else's property. So if one person is bitter that his property value went up and his neighbors didn't, he can appeal to raise the value of his neighbor's property. You also might see an appeal by a local governmental entity. This might be an appeal to change the value of a government property. Now note, government property is exempt. They might be appealing to change the value of that based on a pilot or a TIF agreement, some specific agreement there. And so you might be considering the value of property that won't even be assessed taxes. And you might also see duplicate appeals. Let's talk about what happens if you don't appeal to the county board. If you don't appeal to the county board by the last day when the county board closes their proceedings, then that's it. You pay that taxpayer owes their taxes, and there's no other opportunity to change it. The only thing they can do is they can file a late appeal to the State Board of Equalization, and at that appeal they will have to show reasonable cause for why they did not timely appeal. Reasonable cause will generally be considered reasons outside a party's control. So a lot of times this might be an illness or a death of the taxpayer or family member. And something like that prevented them from attending or from filing an appeal timely. And a reasonable cause will not be that they did not get an appraisal in enough time to attend the county board hearing, that they just forgot, that they did not own the property yet, or that they were not sure what to do. None of those are going to be considered reasonable cause. There's also the very limited option of direct appeal rights to the State Board of Equalization. And this is another method whereby a taxpayer may not have to appear at the county board. So if we look at Tennessee 67-5-1412, specifically says that industrial and commercial real and tangible personal property can be appealed directly to the state board with the written consent of the county assessor. So that's that. Thank you, folks.
Good morning. My name is John Sharp. I'm an Assistant General Counsel for the Comptroller of the Treasury. I begin today. I want to thank you for your service to the County Boards of Equalization in your various communities. I appreciate your service. Today we're going to talk about the burden of proof. The burden of proof can be a somewhat arbitrary subject. For instance, there was a Supreme Court justice, a United States Supreme Court justice named Potter Stewart, who was once discussing a topic before the court, and he said, "I know it when I see it." A critique of that phrase of Potter Stewart came about from Mr. William Goldberg. And Mr. Goldberg said, in replying to that phrase, "I know it when I see it," he said, "I know it when I see it, and someone else knows it when they see it. But what they see and what they know may or may not be what I see and what I know, and that's okay." That can be very confusing. That can be very confusing to an attorney. That can be very confusing to a layman. What our job of our presentation today is to do, to hopefully add some clarity to this discussion. So to give you a working knowledge of the burden of proof. This is our agenda for today. We're going to go through and we're going to cover each one of these topics today. And let's start with the burden of proof. The burden of proof at the County Board of Equalization. A working definition of the burden of proof is the obligation to prove one's assertion. For instance, if I assert it's raining outside, I will have the obligation of proving that assertion to you. This is a legal term that encompasses both the burden of persuasion and the burden of production. So in other words, I've got to persuade you and produce evidence of that fact. The burden of proof should always be considered in the context of your oath of office. And I would just like to read this oath of office to you right now. Take a moment and read this to you. This is a sample oath that's provided in Tennessee Code. I, and then you would state your name, member of the Board of Equalization of such county, do hereby solemnly swear or affirm that I will carefully examine, compare, and equalize the assessments of such county in accordance with the Constitution and the laws of the state of Tennessee, and to the best of my knowledge and ability, I will faithfully, honestly, and impartially perform all duties imposed upon me as a member of the board by the laws of the state of Tennessee. This is a very serious oath that you're taking, and it has direct repercussions to the burden of proof. That's something that you're going to have to consider as the citizens of your community come before you. The next topic that we're going to cover is who has the burden of proof. The burden of proof And who has that is oftentimes governed by State Board of Equalization Rule 0600-01-.11. And that states, in the hearing of an appeal before an administrative judge concerning the classification and or assessment of a property, the party seeking to change the current classification and or assessment shall have the burden of proof. As members of the County Board of Equalization, you're not an administrative judge, but courts have consistently held that in administrative proceedings, the burden of proof currently rests on the party seeking relief, benefits, or privileges. Further, it's well established in Tennessee case law that the burden of proof is on the party having the affirmative responsibility of asserting the issue. In our cases that we're typically going to be dealing with, it's the value of the property. So, if you have the property valued before you at one number, and I come in and I assert a different number, then I would have the burden of proof. And we'll get into each one of these in further detail as we go along. What kind of evidence is necessary? I talked about the burden of persuasion earlier. What's the best way for me to prove my assertion? Back to my assertion about the weather. I said it's raining outside. If I bring in a wet overcoat and a dripping umbrella, in my mind, I have provided evidence to demonstrate to you that it's raining outside. In property appeals considering value, recent photos of the property, comparable sales documents, appraisals of the property, sale, real estate listings, each one of these are types of evidence that you could see. There's also a good listing of these in the State Board of Equalization's County Board of Equalization Practice Manual. I would highlight and refer you to it as a good example of types of evidence that you would see. Our next topic that we're going to talk about, how much proof do you need? Not to be trite, but the amount of proof you're going to need is going to vary on a case-by-case basis. In other words, it depends on each appeal. Each appeal is different, and the level or the amount of proof that you require can vary from case to case. It's not like baking a cake. You don't have a recipe and follow it an ounce of this, 2 cups of that, and a thimble of that. It varies from case to case, and it will vary depending on the amount of proof that you require as a County Board of Equalization. How do you weigh the evidence? Sometimes weighing the evidence can refer to the strength of a single piece of evidence, while at other times it can refer to the whole set of evidence presented. In other words, a cumulative effect. And each case will vary. There can be one piece of evidence that's presented that is so overwhelming, it speaks the day for you. It saves the day, and you understand clearly that I have presented enough evidence and I've overcome my burden of proof. And we'll address that also. What does it mean to shift the burden? Let me give you an example of a criminal prosecution. We've all heard you're innocent until proven guilty, right? Well, if I'm convicted of a criminal offense before a jury, and then I appeal that decision, the jury conviction then removes the presumption of innocence that I enjoyed at the trial and replaces it with a presumption of guilt. Now, we're not talking about innocence or guilt. We're simply looking at the values, the assessment that the assessor has determined for these properties that will come before you. And when these properties come before you, there's a presumption of correctness that attaches to the assessor's valuation. And that's important for you to remember as we work through the burden of proof. That's also important for you to remember as you work through the type of evidence that's necessary. For me, as a appellant before you, as a taxpayer coming before you, what type of evidence do I need to present to overcome that presumption of correctness that attaches to the assessor's appraisal? And that's going to directly bear on how much proof you need, along with how you weigh the proof that I bring before you. And then if I'm successful in presenting my case, then I can shift the burden to the assessor. That's kind of a brief outline of how we're going to work through this today. And if you'll bear with me, we'll get into each one of these topics right now. Who has the burden of proof? The burden of proof is on the party appealing. Generally, this is the taxpayer, but not always. In these appeals, the taxpayer is often termed the appellant. However, these terms are used almost interchangeably. And because of that, there could be times when someone else is appealing. For instance, your local assessor may appeal the valuation. And in that case, the assessor would be the appellant, and the assessor would have the burden of proof. The burden of proof is always initially on the party appealing. We touched on that earlier. I'd like to refer you to, and I'm just going to cite it out, Tennessee Code Annotated 67-5-1401. It implicitly affirms this burden by stating, if the taxpayer fails, neglects, or refuses to appear before the County Board of Equalization prior to its final adjournment, the assessment as determined by the assessor shall be conclusive against the taxpayer, and such taxpayer shall be required to pay the taxes on such amount. So that demonstrates that you have to appear, you have to contest that value that the assessor has placed on the value, and the burden of production, the burden of proof, is on the appellant. And in most of the situations that you will encounter, that's going to be the taxpayer. There could arise a situation where that could be the assessor. There could also arise a situation where that could be a lien holder that's obligated to pay the taxes on the property. Just a quick example of this. Recently, there was an appeal conducted, and the owner of the property did not appeal the taxes, but the owner had a lease in place, and that lessee, the individual that had leased the premises from the owner, wanted to appeal the property taxes. In Tennessee, that's perfectly fine. They have that ability. And they went before the county board and subsequently went before an administrative law judge and had their appeal heard. So you can encounter different situations as to who the appellant is. In most of the situations that you will encounter, it's going to be the owner of the property, the taxpayer. What kind of proof do you need? An appraisal, opinions, photos, documents, income expense statements? Can I just tell you what I paid for it? The County Board of Equalization can see a variety of different types of evidence. It's your job to determine how important, how relevant, how credible, how reliable that evidence is. I don't want you to be intimidated by words like evidence, proof, testimony. At the end of the day, all of these terms are referring to items that you will see. The specific format is not something that you need to worry about, because remember, these hearings are informal. So if I bring to you a written sheet of paper that shows you what someone paid me, that can be evidence for you to consider. Let's talk about this last fact here. If you're being assessed for a home, but the house doesn't exist, should you have to pay the taxes? Sometimes the taxpayer may be showing something that is not what it reports to be. It could be the condition of their property, doesn't match the record, the property record card that you have, or a building that used to exist, but now it's demolished. Don't forget that sometimes nothing is exactly what you're looking for. The absence of a fact can indeed be a fact. One last thing about this. The burden of proof is not intended to be difficult. Let your common sense prevail. If you, as a County Board of Equalization member, do not feel that the taxpayer has shown enough to justify a change in value, then don't change the value. All right, we're going to move to the next slide now. How much proof do you need? The basis of an appeal can be different from one appeal to the next. You simply need enough proof to prevail on the basis of the appeal. If the taxpayer is appealing the value, you need proof of value. If the taxpayer is appealing the classification, they will need to show you proof or lack of proof as to the classification. And I would refer you back to the previous slide where we talked about that. The absence of a fact can be a fact. This next bullet point that we have here is evidence of value. And this is our standard in Tennessee. The value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values. And that's Tennessee Code annotated 675-601. This is a statutory charge for valuing property in Tennessee. You'll see it in Skit 2 in an example of that. There is no evidence about the property, then there is no evidence to support a change. So no evidence, no change. The County Board of Equalization does not need to give weight to evidence that's too speculative. Just because the taxpayer presents some opinion as to value doesn't mean it's a reliable one. So a couple of examples of this is in an appeal once I heard a taxpayer say, I think the county's going to put in a landfill down the road from my property, and that's going to negatively affect my property values. Well, that may be true and that may not be true, but do I as a taxpayer have any knowledge of that, any inside information of that? Is that really going to happen, or is that just me stating that fact? So you'll have to weigh that and consider that as evidence. That's very speculative in my opinion. And it's also very speculative as to whether that will negatively affect the value of my property. And those are things that you would want to consider. Another example that's perfect for this day and time. If I came into you and I said, I think the coronavirus is going to cause a real estate crisis and my value of my property is going to plummet. Is that something that you should act on and lower the value of my property based on my speculative allegation? I think not. But that's a decision that you'll have to make as board members. This next slide is very informative for me, and we're going to talk about the burden of proof. In this illustration, you'll see 3 scales. Each of these scales represent different scenarios. In the first scale, in the upper left-hand corner, it says, plaintiff doesn't have enough evidence to support his or her case. So the defendant wins. In this example, the defendant would be the assessor of property, the plaintiff would be the taxpayer, the person coming before you to contest the value of their property. So if I don't present enough evidence, the scales stay the same. I haven't moved the scales. So in that case, the defendant, the assessor of property, that value maintains. I haven't tipped the scales. In this next case, in moving to the right, in the upper right quadrant, defendant's evidence outweighs plaintiff's evidence. So, the plaintiff would be the taxpayer, the defendant would be the assessor of property. The assessor of property's evidence outweighs the taxpayer's evidence. The scales have been tipped in the favor of the assessor of property. So in that case, the assessor of property wins. They've carried the burden of proof. And our final example on the bottom, plaintiff wins. Plaintiff's evidence outweighs defendant's evidence. In that case, once again, the plaintiff can be the taxpayer, the defendant can be the assessor. The evidence that you have received as a County Board of Equalization, in that evidence, the taxpayer presented enough evidence in your mind to overcome the presumption of correctness that attaches to the assessor's valuation of the property. They've tilted the scales in their favor, and the taxpayer would win. So how much proof do you need? What about the assessor's value? This is our starting point. In this, you would talk about the County Board of Equalization, and you'll hear, and I've said this term before, a presumption of correctness. This is just a fancy way of saying the assessor did his or her job. You have to start somewhere, and the assessor is charged with valuing the property. That's their responsibility under the Constitution of the state of Tennessee and our laws. It may not be 100% beyond a shadow of a doubt the correct value, but it's an excellent place to start. In Tennessee, our assessors use a CAMA system, CAMA, C-A-M-A, and that stands for Computer Generated Mass Appraisal System. However, sometimes you've all heard the term garbage in, garbage out. If the assessor sends me out to measure someone's house and I don't do a competent job of that, I could have a 10,000 square foot house measured as a 100,000 square foot house. I've made a mistake. So that's going to be a big mistake. So the information that goes in is very important for determining the information that comes out of that CAMA system. Now in Tennessee, we have a competent staff across the state, and they're diligent to try to look out for mistakes as these, such as that, as I just described. But mistakes can occur. We're all human and we make them. So if you see a mistake like that, that's something that you could present evidence about, that I don't have a 10,000 square foot house, I have a 100,000 square foot house. A property's value is only as good as the information available. If there are conditions the taxpayer knows but no one else would know, then how would the assessor know how to adjust the value? The assessor can do everything right and then still be appealed. I want to also touch on the point about a typical fee appraisal. We talked about earlier a computer-assisted, computer-generated mass appraisal system and how it looks at all the properties across the county. A fee appraisal is going from a mass appraisal to a single property appraisal. And that's very specific to that one property. There's always room for a discrepancy between the assessor's work and an appraisal a taxpayer might bring in. So I think I've touched on that mass appraisal versus a fee appraisal. And we've also talked about the assessor's valuation being the starting point. That's where you want to look. This is an example of a commercial and industrial sales questionnaire that assessors typically send out to people that have recently bought or sold a home. And you can see the information that's presented here. This is the type of data that the assessor uses to then enter into that CAMA system. If there's a question on here that I don't understand or fill out incorrectly, that can corrupt that data. So it's important that the assessor gets back this information, is able to verify that, and then to incorporate that into the CAMA system. So that gives you a little bit of an example of how a mistake could occur there. As the party appealing, it's the burden of the taxpayer to show the value, not the information they supplied is correct. How much proof do you need? Bad evidence, equal evidence, sufficient evidence. Is the evidence credible? Is the evidence complete? Does the evidence support the appeal? People often ask, do I have to have an appraisal to have an appeal? The answer is no, but an appraisal is likely your best bet. Now, consider this is 2020. If I bring you an appraisal from 20 years ago, is that still relevant today? A lot has changed in 20 years, and I would say no. So you're looking for a current appraisal, not one from 20 years ago. You need evidence that is credible, complete, and supports your appeal. An appraisal typically does all of those things. However, it's also possible for the taxpayer to present enough evidence for an adjustment without a full appraisal. That is possible. If we talked before about an example of me trying to prove that I had a house removed. If I show you if I had a garage and I had that garage demolished, I bring in a current picture of my home, where there's no garage there, that can be evidence that can support that. Of course, in that example, you may want to have the assessor send someone out to verify that. And that's possible. There's employees that go out to verify data all the time. So that's possible. But it's not always an appraisal that wins the day. You want to be open and you want to consider that's the best evidence. Relevant versus irrelevant proof. The job of the County Board of Equalization is to hear appeals of property, not hear appeals of taxes. And you understand, the County Board of Equalization does not set the tax rate. That is the county commission's responsibility. You have no authority in the tax rate. The assessor has no authority in the tax rate. The assessor's responsibility is to determine the correct assessment, and that goes back to our definition of value in Tennessee. The tax rate is set by the county commission. So to hear concerns about the tax rate is not appropriate for the County Board of Equalization, and that would be irrelevant proof. Also, irrelevant proof is the ability to pay. Complaints about business competition, those do not relate to the fair market value of the property in question. Certain complaints or testimony may include relevant proof about the condition of the property, a neighborhood or market, or obsolescence. And those would be important for you to listen to if they come up. So, we've reached the time in our presentation where we're ready for a video example. In this video example, I would like for you to be alert to the evidence and what was presented. Is it credible? Is it complete? Does it support the appeal? Let's go to our video.
Guys, the value on my apartment complex is way off. Based on income, the value should be around $300,000. So that's with 20% expenses, vacancy at 5%, and I've capped it out at 10%.
Well, did you bring your income and expense information with you?
No, I just told you what it is.
Well, Miss Abbott, without documentation, we won't be able to change your value based on income. You should have brought that with you to the meeting.
Miss Abbott, without that information, we have no choice but leave your assessment exactly where it is.
Okay, what did you think about that video? Some great actors there, isn't it? So what went wrong with this taxpayer's appeal? From your perspective as County Board of Equalization members, what went wrong with this video? The thing that jumps out to me is the type of evidence that was presented. It was said, I just told you what it was. There's no written documentation. It's oral testimony. And if someone was so inclined, they could come in and say anything. There's no substantiation of that oral testimony. In this case, I would look for documentation that would provide, that would support the oral testimony that was given. So to me, that's a problem with this testimony. The taxpayer testified as to certain evidence. Why wasn't this enough? Well, once again, oral testimony. And there's no documentation to support that oral testimony. And that's a big concern when you're talking about evidence and how it's presented to you, the County Board of Equalization. Remember, these are informal hearings, but at the same time, you've got to have something to substantiate what's said. All right, let's look at another example here. And when we do this, I want you to be aware and look for what types of evidence you would consider.
If everyone's good to go, I think we're ready for our next appeal. How you doing, Mr. Jones?
Nice to meet you.
My name's Brent. I'm the chair of the county board. As you can see, the other members are here with us, as well as the assessor of property. What brings you in today?
Geez, I really don't know where to begin. It has everything to do with my taxes, okay? I lost my job. I've got some other things going on in my life right now. There is no way I can pay these taxes.
Oh gosh, I'm really sorry to hear about your difficult times. Is there anything you can tell us about your particular property?
Yeah, it's over by that Woodhaven subdivision. I don't know if y'all are familiar with the area or not. It's across the highway, though. I think I've been living there for something like, gosh, 14, maybe 15 years or so. I replaced the hot water heater on it for what that's worth, but as far as like major construction goes, I haven't really done anything.
Is there anything wrong with the property? Any unusual damage or depreciation?
I don't really understand what depreciation means. I don't really depreciate the way you're talking to me right now. But as far as my taxes go, if you don't do something about it, I'm going to be out on the street.
Well, I appreciate your time and effort coming in today. Unfortunately, we can only hear matters that deal with property value. It is the county commissioners who actually set the tax rate, and then taxes are based off of that assessed value. So unless your appeal actually deals with the value of your property, I'm not sure there's much we can do at this point.
Okay, another great presentation. So in this one, what was the basis for the appeal? I didn't really see a basis for the appeal other than the taxpayer's inability to pay. And that is not what we're charged with. We are charged with the fair value of the home, the assessment of the home. And the inability of the taxpayer to pay is not relevant to the value of the home. What was wrong with the taxpayer's assessment? The taxpayer did not, the board asked several questions about the assessment, and there was nothing, no discrepancies, nothing wrong with the assessment that I saw. So unfortunately, I didn't see any basis for the board to affect the valuation of the home. What options are available to the taxpayer in this situation, in this type of situation, and you may encounter this. There's various community organizations that can assist a taxpayer. One that I specifically know of is tax relief. If the taxpayer is eligible and qualifies for that, they can get assistance on the payment of their property taxes. But it's not appropriate, it's inappropriate to lower the value of the home based on the fact of inability to pay the taxes. So, with that said, let's go to our final video presentation.
Welcome. My name is Brent. I'm the chair of the county board. As you can see, the other board members are here, as well as the assessor of property.
Oh, well then you're to blame for all this, I guess. Look, all I ask for is that my property be valued the same as all my neighbors, all right? And I got all the proof that I need right there.
Huh. That's a lot of information. Are there any sales from your area in here?
What? No. When I got my assessment change notice, I looked up my neighbor's values on the computer, and it said that their values were half as much as mine.
That's great. To begin, could you tell us a little bit about your property in particular?
Sure. I guess it was built around 2012 or something like that, and it's got 3 bathrooms, about 3,500 square feet, but it's assessed at like twice as much as my neighbor's.
What are the other properties like in your neighborhood? Are they similarly built? Are they roughly the same size?
No, not really. Look, I got all the information right here. It don't do no good if you don't read it. All right? I printed it all out on the computer, and it says that everybody's house around me is priced for half of what mine is.
Do you have any neighbors that have a house that's similar in size or year built? When I look at this, it appears that your closest neighbor is about 2,000 square feet and built in 1989.
No, I don't live in one of them little cookie cutter subdivisions. All right? I live out kind of by myself. There are houses around me, but you know, now that I think about it, those houses are a little bit different than mine, and I guess I do have one of the bigger houses out there.
Unfortunately, without an actual appraisal, there could be a million little reasons why your neighbor's properties are valued differently than your property. Lot size, square footage, age. An appraisal would factor in proper adjustments that would compensate for the differences in value. Without proper adjustments, I'm afraid we can't use your neighbor's values as a basis for your property's value.
Well, what good are you?
All right, another excellent video. What was the basis for the appeal? The taxpayer asserted their property was overvalued compared to the neighbors. The taxpayer's property, was it comparable to the neighbors? in the testimony that was presented, it's not true. It was not comparable. The evidence that was presented was appraisals of other properties, but they're not comparable. And what you saw was the appraisals without adjustments. That's what an individual appraisal would do. A single property appraisal would take those and then adjust those figures. A 1,000 square foot home compared to a 2,000 square foot home would have a different value. And that's what's lacking in this evidence. In my opinion, the evidence is insufficient to overturn the valuation that the assessor has attached to this property in this example. If, on the other hand, you saw a single property appraisal with comparisons to the neighbor's properties that had been adjusted, that would be a different consideration for you. But just to compare one value to another value, you could be comparing an apple to an orange, and it's not a fair comparison. My neighbor, personally, has a nicer home than I do. His home is much larger than my home. So I would not think it would be fair that his home would be valued the same as my home. And you probably can think of examples in your own neighborhood where that's the case. As a matter of fact, the taxpayer testified, my neighborhood is not a cookie cutter neighborhood. And that's true. So you can't take a cookie cutter approach to valuing these properties. Why did the taxpayer's assessment go up when the neighbor's assessment didn't? It's possible that in this case, larger homes across this community saw an increase in value, while smaller homes could have seen a decrease in value. We don't know because we don't have all the facts. We're looking at a small slice of the pie, this one neighborhood, and we don't have all the evidence. I believe, in my opinion, the taxpayer has not presented enough evidence or the quantity of evidence that you need to tip the scale. They've not carried their burden of proof. I hope this is helpful to you. And in closing, I want you to remember these topics that we talked about. The burden of proving the case is on the party appealing. The taxpayer must present enough evidence to support their continued value or relief requested. It is your responsibility to use your judgment in determining how much weight to give certain evidence. Only if you feel the taxpayer has met the burden does the assessor need to defend that value. Decisions should be based solely on evidence and not on feelings. In conclusion, I appreciate your service to your community. Thanks for being here today. Have a great day.
Hello, and once again, my name is Robin Pope, and I currently serve as the Deputy Executive Secretary with Tennessee's State Board of Equalization. Now, I know you've already covered a lot of topics about the State Board of Equalization, your powers, responsibilities, and duties. We just have a few more things to cover, and also some helpful suggestions as to how to run your board hearings and appeals that you may receive. Specifically, we'll cover kind of an order of proceedings and get to more into what that means and what that means for you specifically as the county board, as well as how long should a hearing be? Some basic questions we have here. How to record your decisions about your hearings you may have. What happens to the changes you make, as well as the records that you may receive or create in the order of your operations. And finally, your most important duty, certifying your assessments. So the order of proceedings is generally how you'll operate for your appeals that you receive from taxpayers in your jurisdiction. This can be a very sort of, very formal proceeding, but let's remember from earlier, it's a pretty informal setting we have here. You don't have to reach for that gavel and put on the robe. This isn't a judicial court proceeding. A simple hello, let's get things started. As well as if you wanted to, the chairperson could kind of say, we're going to bring these meetings to order and kind of have a little bit more decorum. So you generally are going to start with your chairperson just introducing themselves as well as the other members and generally calling the meeting to order. The chairperson should explain the nature of the appeal they're about to receive. Your information may differ from county to county. One county may know a lot about the appeal they're about to hear. They may know the taxpayer's name, the property location, and the basis for appeal, as well as some other general introductory information. Other counties, you may just know the taxpayer's name, and that's quite all right. It's just giving a grounding and a sense of direction for what you're about to do. You can also then swear in anyone who needs to give testimony. Again, this is not a sort of formal court proceeding. It's just a simple, do you swear or affirm to tell the truth? It's a simple oath, and it just makes sure that anyone who gives testimony or who wants to speak about the exhibits or information you're about to receive has taken an oath to tell the truth. Next is the substantive part of the hearing. This is really where you're going to start hearing evidence and more information about the specific property under appeal. This is really, like a court proceeding. This will be a bifurcated sort of two-step process. Of course, the taxpayer and the person who appeals will generally go first, and they'll present their argument, their reasons, their explanation, kind of whatever they have that they want to present to the hearing and to you to consider on their appeal of their property. Next, the assessor also has an opportunity to kind of respond to any accusations, any sort of evidence that was presented, as well as defend the value that they originally assessed the property. This is a two-sided hearing, so you do have two opportunities from both the taxpayer to give their point of view, as well as the assessor to explain why they value the property at a certain amount. During either side's presentation or throughout the presentation, you are allowed to make questions. Ask the taxpayer, ask the assessor. You have a lot of freedom. And remember, these proceedings are pretty informal. This is a suggestion of best way to kind of order your proceedings, but it's really what works best for you in your county and in your hearing. Not every hearing is the same, and not every taxpayer needs the same sort of level of formality. Once you've heard all the evidence you're going to consider, it's next time to move into deliberations. Once deliberations have begun, it's important that no other new testimony is heard. Your deliberation must also be on the record and be an open meeting. As a board who's going to make a decision, it's important that your testimony or your conversation about your deliberations for what you believe should happen in an appeal are open. And although the taxpayer and assessor cannot contribute during your deliberations, they are able to remain in the room and kind of listen to what you have to say and to listen to how you base your decision on. If you want to receive additional testimony and evidence, you absolutely are able to. However, you must make a motion to reopen the record and therefore allow additional testimony from the taxpayer or the assessor. This simply means that you've moved from deliberations back into the hearing of evidence. Once you've deliberated adequately or someone has made a motion and received a second, you can then vote on that motion. Anyone can make a motion as to the value of the property. It doesn't necessarily have to be the chairperson, but anyone can, but it can often will be the chairperson who will make a motion as to how they want to resolve the appeal, whether it be by accepting the taxpayer's submitted value or by going with the assessor's original assessment. The options are varied and will depend on the evidence you've received. Once a motion has been made and seconded, the members will vote on that motion to determine if it passes or fails. This process can take a lot of time or no time at all. It really depends on the facts and circumstances in front of you. Often, the average length of a hearing will be about 15 minutes, and that includes from introductions to your resolution. It can go up to almost 2 hours, so be aware that the complications that are involved in an appeal can be varied. It's important that that the taxpayer receives every opportunity to be heard. And so whether it's 15 minutes or 2 hours, it's important that you take the time necessary to make an adequate and informed decision. It's also important that you make a record of your hearing and a record of your decision. What your record may consist of may vary depending on county to county. Some counties may have a more sophisticated recording system that incorporates video as well as audio of the hearing that took place. Other counties, it may just simply be an audio recorder that's left on the desk. You may not have any of these options. Instead, it may just be your secretary with the county board who takes meeting minutes, and that may be your entire record of the hearing. All those are fine. It's important that you just have a record of what happened to those proceedings. The requirement, though, is you have to have that record, a daily record of transactions, and it is signed by the board. So again, no matter how sophisticated or approachable your recordings are, it's just important that you have that record and sign it. Once you've reached a decision, a notice will be sent to the taxpayer of what that decision was. It's also important that that notice is sent at least 5 days prior to the date property taxes are due. That notice also has a lot of information it's required to have. It has to have, most importantly, the notice of your final decision. That would be the value that you decided the property should be, or the classification you determined the property should be, or a myriad of other options, as you well know from our prior sessions. You also must include notice of the appeal procedure to the State Board of Equalization, notice of the taxpayer's rights to file electronically with us, as well as the current address of the State Board information and any other relevant deadlines. All of this information is currently available on our website, both including where to apply. You're going to appeal to the State Board electronically, as well as some other helpful information about the payment of property taxes while there is an appeal pending, and other helpful information is all available on our website. Once your businesses have concluded with the County Board of Equalization, it's time to certify your assessments. As for all your records and papers you may have received, upon completion of your duties as the County Board of Equalization, you'll turn over any papers you've received to the assessor. The assessor will then preserve these important records, like your meeting minutes, for a period of at least 10 years. And then individual property record cards will be updated accordingly. Now this mainly applies to records that you have created, not necessarily records that you've received during the scope of an appeal. Rely on your assessor to help you figure out which records need to go to the assessor for preservation. So we've covered just a few wrapping up topics, mainly about how to navigate your appeals. We've also talked about the changes that you've made and how those changes will be communicated to the taxpayer as well as preserved for the record. Don't forget your most final important step is to certify your assessments of the county board. And we also talked about what happens to those records. If you're looking for other resources or other help about what powers and responsibilities you need to accomplish this year, be sure to check out our website at www.comptroller.tn.gov/SBOE. From there, we have a lot of varied of resources, including a copy of the County Board of Equalization manual available on our resources tab, as well as additional information about how to appeal property taxes in Tennessee. I hope you found this helpful and informative. Thank you.
Hello, my name is Christina Gregg. I work with the Division of Property Assessments. I'm going to speak to you today about some of the roles that the property assessor fulfills, their various assessment functions, and to introduce you to some of the tools and resources that we have available and that we use as part of our reappraisal programs. So first we're going to talk about the assessment calendar. There are a lot of dates that will pop up throughout the year. Oh, here it's still going. That some will affect your appraisal, your appeal process, and some are directly related to the roles that the assessor does. So the assessor works off of multiple calendars throughout their whole reappraisal cycle. You'll see property assessor, you have your year 1, year 2, you have your things that you need to accomplish between reappraisal programs. So that's one calendar that you're working off of. Of course, like any office, you have you have your fiscal calendar that you're working off of. This assessment calendar has dates that come up every year for every assessor. January 1 is not just a holiday, it's also your assessment date. Your assessment date is the status of your property as of that date. It means who owns the property, what they own, and the condition in which it stands on January 1. So January 1, you have Mr. Smith owns a piece of property. He sells it in February or March, and then the new owner comes before the county board or wants to make an appeal to the county board for his value. Because he is not the owner on January 1, he would not be the proper person to make that appeal. So this is where your assessment date really affects the appeal process for some taxpayers if a sale has taken place. March the 1st is a busy day for assessor's offices, not just because Greenbelt applications are due, so you'll have your farmers or people that have agricultural property that they've purchased or that's changed hands coming in to turn in their applications, but you'll also have your business owners that will be lining up to turn in their tangible personal property schedules. These schedules we'll talk a little bit more about later on and what to do if they miss that March 1st deadline. Your assessment roll is due by May the 20th, and May 20th is also the deadline for exemptions, exemption applications to be submitted to the State Board of Equalization. June 1st, of course, is a date you'll all be familiar with because that's going to be the date that our County Board of Equalization convenes. That's when the work really gets started, and within the month, the tax rate should be set within your jurisdiction. August 1st is a deadline for local appeals to the State Board of Equalization, but if the notice for the county board action is submitted later, then it would be within 45 days of that notice. So some of your larger counties, you'll see that they'll have county board sessions that just run a little bit longer. If it's towards the end of June before that action is sent, then the taxpayer would have 45 days following that action to submit that appeal to the state board level if they weren't able to come up to a satisfactory resolution with the county board. The first Monday in October is when our taxes are going to be billed. This means that the trustee is going to collect the taxes in the amount set out in the tax roll, and that's delivered to the trustee on or before the first Monday in October every year. Let's talk some more about the specific role of the property assessor. The assessor is supposed to appraise and classify all property within a jurisdiction. That's real property and it's personal property. The assessor then applies assessment ratios to all properties based on their classification, and these new values are known as assessments or assessed values. Your assessment ratios are determined according to the classification of the property. So if you are just your regular taxpayer, you have a home and a piece of land, it's residential, or let's say you have a farm, it's 15 acres or more, your property is going to be assessed or have an assessment ratio of 25%. This means that you'll take your total appraised value multiplied by 25% to come up with your assessed value. That assessed value is then multiplied by the tax rate in your jurisdiction to come up with your tax bill. Now, we're not talking about personal property that's had an equalization ratio applied, and we're not talking about interest, but generally your tax bill is going to be your appraisal multiplied by your assessment ratio to equal your assessed value multiplied by your tax rate. Is that confusing yet? So, and keep in mind too, different jurisdictions will have different tax rates, and each county will have multiple jurisdictions. So you're going to use this formula for calculating your county taxes, and then your city taxes, and then the smaller city that lists that's inside your county. So each of them will have their own tax rates. Remember, we talked about the calendar too. Those tax rates should generally be set by July the 1st. Commercial property has two different assessment ratios, real and personal. Your real commercial or industrial property is assessed at 40% of its total appraised value, and personal property is all assessed at 30%. Again, that's not taking into account the equalization ratio. So all assessors are elected according to the Tennessee Constitution for a 4-year term. Their job is to identify, list, appraise, and classify the property. So we're just kind of adding on to this a little bit at a time to kind of give you a big picture of the things that the assessor does throughout the year. So we talked about it's their job to appraise, to come up with a total appraised value. It's their job to classify that property based on its highest and best use. But in order to appraise, they have to know where it is. They have to list it. They have to know who owns it. They have to have a parcel identifier. And this is all part of what the assessor is doing throughout the year in addition to their regular reappraisal programs. They're also a resource to property owners. All of you out here that work in assessor's offices know a big chunk of your day is not about your reappraisal program. It's about helping that person find where their fence line should lay if it's encroaching on another person's property. It's helping a widower who wants his wife's name, removed as the property owner, bringing in death certificates. It's helping people through the day-to-day of their lives and to give them resources to help them through their appraisals and their appeal process. According to this statute, every assessor should have and maintain their own program to verify sales of real property in their county. Accurate sales information is needed for use in all types of valuation programs. Current value updates for our 6-year counties, sales ratio studies, and of course, our reappraisals. This is a really valuable resource that the assessors will use when they're qualifying the sales in their county, making sure that the sales meet all the criteria of a good arm's length transaction. This is the Sales Data Collection and Verification Manual, and it is available online. The assessors are going to build market data based on the recent sales in their county, so they need to sort which sales are good and which are bad. If the sale does not reflect accurate market trends, then that sale should be disqualified. How should that sale be disqualified? It might be disqualified because it's a family sale. It might be disqualified because the person that purchased the property got a 3-for-1 deal. He bought 3 lots in a subdivision side by side, and the person that owned all 3 lots, cut a little bit out of it so that he could get rid of all 3. There are a million reasons that a sale might not accurately reflect other sales within that neighborhood. So we want to make sure that those sales are consistent and understandable and that we verified all the ones that we need to. This provides assessors with guidance in the development and maintenance of an accurate, complete sales file. This is an example of a sales questionnaire. TCA 67-5-601 says that all farm and commercial industrial sales must be verified to determine if they meet the requirements of a valid, qualified sale. I'm going to keep reiterating that because as you're looking at property record cards towards the bottom, and we'll go into this a little bit more later, there's sales data on that card. And lots of times you might have someone come into an appeal and say, I only paid X number of dollars for this piece of property. You need to be able to, and the assessor can explain to you whether or not that was a valid sale and what some of the terms of that sale might have been. For residential or farm property, we're going to ask questions like, was the sale, did it take place as an auction, or was it listed through a realtor? Some things you may not think matter. You could argue that property that's sold at auction is still consistent with the local market. But what if it was a really rainy day, there wasn't a good turnout? What if the auction happened because someone had passed away and they were trying to liquidate the assets really quickly because they were just trying to get rid of everything, and it wasn't really about, getting a fair market price and having it sit on the market for a reasonable amount of time? But what if they were just trying to hurry things along? It's not an automatic disqualification, but it could be an indicator. And so that's why we ask on the questionnaire. Some of the other questions, whether or not any physical changes have been made to the property after the sale. One disqualification would be physical difference. So if someone has purchased a property and then has immediately built a garage on it, that garage, of course, has been picked up by your assessor and their field staff. And now the card has a house and a garage, and the sale price on the bottom doesn't reflect a house and a garage because he just bought a house. So did that money buy what's assessed on the card? If it doesn't accurately reflect, if the sale doesn't reflect the physical characteristics on the property record card, then that sale can't be used as a determination of what the market is for that kind of property. This is a commercial questionnaire, commercial or industrial, and it's very much like the residential questionnaire with a few small differences. It asks whether or not the property is leased, and if personal property was involved in the sale, do you have the value for that personal property? This can be extremely valuable in counties where there are not a lot of commercial sales. I came from a county where being able to verify these sales was vital to establishing good and correct appraisals for our commercial properties. So we needed to find out as much as we could about each of these sales as they occurred. If you had, for instance, a hotel that sold, typically you're not going to see a hotel sell from one owner to another and the new owner has no intention of using it as a hotel. So let's make the assumption that the new owner is going to use it as a hotel as well. There are probably going to be a lot of furniture and fixtures, the TV. They're not going to keep, the old owner's not going to keep all the beds and move them into another place. So let's assume that all of that stuff is going to stay. When an appraisal is done on the personal property alone and the buyer, the seller knows that value, that number can actually be deducted from the sale price to create an adjusted sale price. That adjusted sale price now only reflects the real property that was sold as part of the sale. So the real property can be qualified. It can be a qualified sale. We can use that data to help us appraise other hotels within that jurisdiction. I said we would come back to tangible personal property, and here we are. Personal property schedules are self-reporting. My husband owns a business. This is his least favorite time of the year because it can be a mad scramble to think of, okay, what equipment have I purchased in the last year? What have I gotten rid of? Remember that assessment date, January 1. So you're going to fill out, business owners are going to fill out their schedules for the things that they're owning that are being used or held for use within their business as of that assessment date. The schedules need to be completed and filed and signed by the business owner on or before March the 1st of every year. Taxpayers who file their schedule after that March the 1st deadline may have their schedule presented to the County Board of Equalization prior to its adjournment. With the approval of the County Board to accept the late filed schedule, the account would be identified as board forced. By not filing the schedule, taxpayers forfeit their right to amend the schedule, and they're not entitled to the equalization ratio for that year. Let's say they didn't get it turned in even after March the 1st. The assessor then had to force a value based on information that they might have to make a determination of what the appraisal should be for that property. The business owner, or not the property, but for the business owner can come before the board with a completed schedule, preferably with an asset list, and the board can choose to accept it. Again, they won't have the benefit of the equalization ratio, but they can accept the schedule. If there's an appraisal, sometimes they'll have an appraisal as well, but it's not required. So we talked briefly before about the different assessment cycles that exist for counties as options. 6-year cycles, most of us know, are subject to a current value update in year 3. May be subject, I should say. If you have not experienced a certain amount of growth, then there's not going to be a current value update. But 4 and 5 year have to, their county legislative bodies must adopt a resolution for a 4 or 5 year plan. 6-year plans don't need a resolution because that's considered the legal standard. Regardless of the cycle, all the plans need to be signed by the assessor, the county mayor or executive, and the chair of the county commission. Often that's the mayor, but not always. So you have your appraisal plan, 4, 5, or 6. Let's assume you have a 5-year like this county up on the screen. Systematic field reviews have to be done. They'll break up. You may see a map of your county with this grid laid over the top. Those numbers are all your map numbers. And the county is broken down according to these map numbers. Your field staff will assign, or you'll work with the assessor and the state will work together to come up with a program for making sure that every map gets viewed between reappraisal cycles. So you have the county divided out into sections, and different sections on the grid will be reviewed until the entire county has been updated. So this part in yellow at the top could be year 1. The part in the middle or at the bottom could be year 2, year 3, year 4, and so forth. And then your 5th year, you're looking at your revaluation of the entire county. We talked earlier about that gentleman that just has a piece of land and a house, and he's just sitting in his house and he hasn't really made any changes. It's very possible that he's not going to see any changes to his assessed value between reappraisals. But what about the people that have made some changes? If you work in an assessor's office, and you may see this some in your appeals, you'll have someone come in and they'll say, my taxes are going up every year. Every year I get one of these assessment change notices, or every year my tax bill is a little bit more. What's the deal? And you might have someone say, oh, well, we can't change the value between, reappraisals, but that's not exactly accurate, because if there have been new improvements to your property, your assessed value is going to change. If, let's just do a scenario. You have a gentleman that owns 2 acres and a little house. He buys 5 acres next to him. That year, his assessed value will change if he decides to join those 2 properties together. So, in theory, his tax bill went up, right? Year 2, he has a son and a new daughter-in-law, and they want to build a house on the property. So they start construction a little bit later in the year, maybe July or August. It gets picked up, but it's not completed, so that value is prorated, right? The assessed value will go up a little bit more. The next year, the house is completed. So it's now on at full value, sitting on the full 7 acres. Year 4, let's say there was a reappraisal. There's a revaluation. Everybody's value became adjusted according to the market, and maybe he saw an increase because of that. Maybe the county has just, had a new factory and property is selling quickly and things are doing well. People are paying a little bit more than they were 5 years ago. let's say the year after a reappraisal, they have to build, some new schools, or some road construction needs to be done, and the tax rate goes up a little bit more. Theoretically, you could have an increase every 5 years. Every year for 5 years or more. And that's why it's so important when you do have someone come in that they say that, your assessor can actually go back and look at the property records cards and tell you, did the assessed value change, or could this have been due to a tax rate change? If the assessed value stayed the same, we'll talk about the differences between the assessment function and the taxation function. The difference between an appraisal and mass appraisal. Your appraisal is the most probable selling price for one piece of property. Mass appraisal is the systematic process of valuing a group of properties. Mass appraisal uses market data, standardized methods, and statistical modeling. The assessors of property often rely on valuation equations, tables, and schedules developed through mathematical analysis of market data. Mass appraisal is just one step in developing the assessment roll, the official list of properties that are assessed for property tax purposes within a given jurisdiction. Remember, we said in Tennessee the assessment roll must be completed by May 20th. When we're doing the appraisal process, it's very important that we have correct physical characteristics so that we're valuing things equally and the way that they're actually reflected in the market. So you might have two ranch-style houses right next to each other. They were built in the same year. They're similar styles. They're both brick, but one has a metal roof because it's been recently replaced. And the other one has a detached garage that someone has converted into an art studio. And one has an attached garage that's now been converted into living space. And all of these are differences that should be reflected in the value of those properties. So we have computer resources, we do mapping overlays to find improvements. Some of our larger counties have all kinds of technological resources to find a lot of these, and some are just, pulling in driveways, making sure we're walking around the building, looking to make sure everything that has been picked up is accurate. That's where experience comes in so handy. You know that just by viewing something from the street, there could be plenty of stuff in the back that you're missing. So that's where experience and judgment can be really vital into having a good reappraisal program. It's knowing the questions to ask and knowing what to look for. It's important to remember that property tax rates are determined by local governing bodies. They are completely independent of assessed values. Assessed values may be used in determining what those tax rates need to be, but it's important that you know that when someone comes into a county board hearing and they say, I know why those taxes went up. It's because, I know why my appraisal went up. You think my house is worth $500,000 because you're building a new school. The two functions are completely separate. It's the property assessor's responsibility to appraise the property, to determine what the market value is for that property, and then to classify it so that the correct ratio is applied. Taxation is a separate function. It's the trustee's responsibility to issue the tax bills and to collect those. The county board exists to address problematic appraisals, not tax bills. Budget and fiscal concerns may affect the tax rate, but they should never affect the appraisal. Is that okay? So what type of evidence should we look for? If the taxes being too high is not a factor, what are some things that the appellant could bring into a hearing that could address a value change? The thing that we would like to see, obviously, are comparable sales, because especially for residential property, that's going to be the market data that we use to determine what our county's values should be. If they have recent photos, especially if there's any kind of damage to the property, giving someone a recent photo putting it in front of them and showing them what the house is actually like can be a good determination when you're looking at that property record card of whether or not there's something that's not accurately reflected. Insurance can be interesting because there could be some good data in this. What you have your property insured for is not necessarily what the market value should be, but it can be a good indicator of whether or not we're in the ballpark. Typically, you're not going to see someone have their property insured for $500,000 and then come in and argue that it's only worth $200,000. So again, it's not an indicator of value, but it can be have some helpful information. Obviously, a recent appraisal of the property is wonderful if it wasn't being determined through a bank, just for the purpose of taking out a loan. But if there's a recent appraisal of the property, lots of times, again, it will include those comparable sales, and that will have some really valuable data. Some other good evidence could include architectural plans. This is especially if they feel like there could be a discrepancy in the square footage in the living area, what we call like SFLA. We measure our improvements from the outside. If they have architectural plans that say that their house is only 100 feet around back and we have it, measured at 120, 140, that can be a valuable tool. If they are saying that they built their house for a lot less, or especially if it's like a commercial or industrial property where cost data, the cost approach is frequently used, any kind of cost data could be really helpful. We'll talk some more in the next slide about incurable physical or functional problems that can exist within the property. Again, this is where some of those photos can come in handy. And a real estate listing, I kind of think of the same way I do the insurance. It's not necessarily an indicator of the value, because the value should be the most probable price for a piece of property. We all know what you ask for property may not necessarily be what you receive for it, but it can be a good indicator of whether or not we're in the ballpark. Some unique problems that could pop up. These are where the pictures, again, could come in handy. Damage to your home that is not consistent with the area around it. It may be maybe you just had a really terrible builder and your house is falling apart at a faster rate than your neighbors. Physical depreciation that's not accounted for on the card can be valuable information. This picture cracks me up. The last time I checked, a potty in a kitchen was not the most desirable feature for a home. It's what you would call functional obsolescence. When the cost to cure it is prohibitive, and that is not accounted for anywhere in the value of the property, that could potentially justify a change in value that the county board could then decide upon. Economic or external obsolescence are not things inside the home, they're things outside the home that can't be changed. Let's say you are the only house in the neighborhood whose son's bedroom window opens and the view is blocked by a bridge, a giant concrete bridge. That could affect your sale price if you're selling your house that's like other properties, with the exception of this one external factor. We all know we're not perfect, and mistakes can happen. So be sure that the property record card accurately reflects the actual property and doesn't contain any errors or clerical mistakes. It can be an easy thing to tack on an extra zero. when you're putting dimensions for, an other building yard item. You can also check to be sure that like properties within a neighborhood are valued consistently. Remember that you can't change values for properties that are not under appeal, but this can be a tool to see whether the appellant's property was appraised fairly compared to others. And your assessor is always there to help. They may be able to answer questions specifically about the neighborhood in which something sits. Someone could argue that, there is some external obsolescence. There could be questions that the assessor can answer about why they made a decision that they made, why depreciation was added or wasn't added for certain features. So they can't, they shouldn't lead you into making a decision, but they can inform you about the process and the information, with the information that they have. The role of the county board is to serve the taxpayers in your county. It's by listening, it's by giving them an opportunity to present their grievances concerning their property value. Again, not their taxes, but their property value. As you no doubt heard, or you will hear, these property values need to be consistent, equitable, and verifiable through evidence. The evidence is key because without it, we're making decisions based on our feelings. The taxes may be too high, but that doesn't mean the appraisal is. Now I want to talk about a little bit of what the Division of Property Assessments does. We talked about the assessor's role, and it's the Division of Property Assessments' job to serve the people of Tennessee by ensuring a fair and equitable property tax administration. We do that through monitoring the work of assessors to ensure that proper procedures are followed. We provide technical assistance throughout the year and especially during our reappraisal programs. And we provide manuals and educational programs for use by the assessors. Now, as part of the Comptroller of the Treasury, we also work to fulfill the Comptroller's mission to make government work better. The Division of Property Assessments also utilizes GIS and mapping tools. We have geographic information systems, that's what GIS is, to assist local assessors of property in daily operations. GIS is also used to assist local governments with redistricting. The DPA's GIS professionals are responsible for overseeing the maintenance and distribution of statewide parcel data. This is an online resource that's available to anybody. So your county board or your taxpayers can go on to the Comptroller's website. It's comptroller.tn.gov. Can go up this red bar across the top to Office Functions. Click the drop down and you can select Property Assessments. And you can access all kinds of the manual that we talked about, the Sales Verification Manual. There are handbooks for things like greenbelts, appeals, back assessment and reassessment for personal property, and annual reports for the division that give details about what it is we do all year long. There's a lot of interesting and useful stuff on here to help taxpayers familiarize themselves with the world of property assessments. Another resource that taxpayers can use in their home without having to go up to the assessor's office and have them look up individual pieces of property. I know some assessor's offices don't have public computers, so they're using staff to assist people that come in. But taxpayers can actually go on to this real estate assessment data site. I always find it by Googling Tennessee Property Data homepage. And they can search and view property data not only in their county, but across 84 of our 95 counties. The formatting looks a little different than the property record card that we'll be going over in a minute, but the information included will be the same. Taxpayers can pull up their maps, search values and recent sales in the neighborhood, and they can arm themselves with information that they need for their appeal before they walk into your boardroom. So this is a great tool for the public. We want to go over a brief introduction to the property record card, especially for new board members that maybe haven't familiarized themselves with them. There's a lot of information on the card, and so we want to touch on some of the highlights so that you can kind of see how some of these things are calculated and where some of the numbers come from and where you can find it on the card. This is just one property record card. It's just a generic card. You can see up in the top right-hand corner, there is a breakdown of values. Towards the bottom, these are outbuilding and yard items. We actually have a section for land and a section for greenbelt land. Sales data is toward the bottom. And here on the left-hand side, you have a lot of features of the property. Some of these features drive value and some don't. So we'll touch briefly. Of course, there's a sketch right there in the middle. That should be a sketch of the improvement. That's not a picture of the land. You're going to see the layout of your land on a map. Let's look at the top right-hand corner where we have our appraised value breakdown. So first you're going to have your land. That's your total market land value. That is not, if you have agricultural property and your property is under greenbelt, you'll see that that assessment will be a little bit farther down. Your greenbelt assessment will override your total land market value. You'll have your improvements. This is going to be the improvement of, if you have a house and some, other building or yard items, this will be all of those added together with depreciation calculated in. And there's also a little information about which approach was used for the valuation. Let's talk briefly about market land. You're going to have your market land section values divided up per line, and there will be different units per line. This is a residential property, so all the units are together. You'll have a table. These tables are different county to county, and their evaluation like per unit on each table. So impact will use the table and the number of units to get a rate, and then they'll apply adjustments to the rate to get an adjusted rate. Adjustments to the rate could be made because the land is particularly hilly. Maybe there's an abnormal amount of water that sits on it. Maybe it's a bunch of standing water or flooding. There could be a size factor. It could be just a really odd shape. Sometimes you'll have a property that has no road frontage, or it's a really narrow shape. It's maybe a good size acreage, but it's not enough to build on because of the way that it's cut. And so all of those can factor into the rate that's adjusted. That rate is then multiplied by the number of units, and there you have your land value. There's a greenbelt land section that's to the right of your market land, and this has your use schedules, your soil type, your access, which does not drive value, and your number of acres. This works similar to the market land in that your use table will affect your rate multiplied by your acres to come up with your use value. It's important that county board members know that you cannot make changes to the use schedule. The use schedule is set. If you have someone that comes in that says their appraisal is too high and their property is under greenbelt, yes, you could have the discussion about the improvements, because improvements are not discounted. I don't like the word discounted, but they're not reduced because of greenbelts. But if the number of acres are incorrect, you could then theoretically, if that was corrected, the value would change. If the argument was made that the use type was incorrect, let's say that they have it listed as pasture and it turns out it's just, it's completely wooded, it's completely overgrown. Those are things that would drive value, but you can't make changes to what the greenbelt value actually is unless those corrections change the value. Does that make sense? So we said that there on the left side of the property record card, some of these features will drive value and some of them will not. Along the top, you have your heating and air, the number of stories, the kind of siding. Of course, your year built, your age, and your condition are going to be factors. The quality. There's also a place here you can see depreciation, physical percent good, and there in the middle it says other physical, functional, external. That's going to be that obsolescence that we talked about earlier. So any abnormal depreciation you might see in the other physical, functional obsolescence, that's going to be your toilet in the kitchen, and external, that's going to be your bypass right in Billy's bedroom window. The commercial building data. This section is calculated by the rate for each improvement. So you're going to have the depreciation and the area and the grade that are going to determine values. Then you're going to have the values of the additional features from the commercial interior or exterior part of the card, and the commercial feature section is also going to affect the value. Your dwelling data, only reflects the main improvement, but you also have outbuildings and yard items. Your shed, your wood deck, your detached garage unfinished, like we see here on the card, are going to depreciate differently according to their type. So every outbuilding and yard item doesn't depreciate at the same rate. Your wood deck is going to probably age quicker than your detached garage unfinished. So you have your effective year, you have the grade, which usually is the same as the condition, but not always, and you have your units. So each OBY item will be based on the area of the OBY multiplied by the rate, the grade, and the depreciation for each OBY from the OBY tables. Let's take a minute to talk about some of the approaches to value. There are different ways to skin a cat, so to say, and depending on the type of property that you have and the data that's available to determine what the market trends are for that property, that will affect the value approach that your assessor's office will take to arrive at the total appraised value. We're going to talk briefly about the formulas and the data that goes into developing things through the cost approach, the income approach, and the one that we'll see the most with residential properties, which is the sales comparison approach. So let's talk about the cost approach first. Essentially, this is developing the cost to build a property. You add in the land value. Of course, we're going to determine that value as if the land is vacant. We're going to make sure that we understand fully what the total cost to replace that improvement is, and then we're going to subtract depreciation, based on our age. We're then going to add in other improvements. So you'll have your total cost new or replacement cost new, so we call that an RCN, minus your depreciation to determine your building value. That's just your building value. You're going to have to add the land value as is vacant and the other improvements to arrive at the total value. So this is singular, I would say. You're not comparing it to other properties. You're using the cost to build this specific property. So you're not going to see this for improvements that have a lot of market data. It's not going to be the type of improvement that buys and sells, that people are buying and selling every day. Income approach Obviously, we're going to see this more frequently with income producing properties. And there are different kinds of income that go into it, so we're just going to discuss this very briefly. Your potential gross income is the whole kit and caboodle. It's all the income that comes in. It's gross. It's just gross. Your potential gross income is the absolute maximum. Let's use an apartment building as an example. So you have your apartment building. If every single apartment is let out and everybody is paying their rent and everybody's paying on time, that's your potential gross income. You will subtract your vacancy and collection loss, because we all know for an apartment building, there will be vacancy, there will be collection loss through people not paying. That's subtracted to come up with your effective gross income, or your EGI, for the purpose of this equation. From your EGI, you're going to subtract your operating expenses. This is where things can get dicey. When you have someone that has commercial property come in, it's really important to understand what are appropriate operating expenses and what are not. And the Division of Property Assessments can help you, and certainly your property assessor can help you ascertain whether or not things are properly being subtracted from that to arrive at your net operating income. This net operating income is then divided by a cap rate that is set to determine the value. The income approach, again, can be complicated. There's a lot to it. It's very important that when someone comes in that they bring as much information as possible to help you use those numbers to make a determination of value. Finally, let's talk about my favorite, the sales comparison approach. These are typically going to be our residential sales in which there's just a lot of data, and we're going to use those to determine what the market value is for residential properties typically. This is where data collection is so important. You know, we talked about the sales verification manual, garbage in, garbage out. If we have good sales data, that's when the sales comparison approach is really going to shine. Residential properties are going to be analyzed according to type. Obviously, we're going to break them up into similar properties. They're in like neighborhoods where the market is consistent, and we're going to apply adjustments based on any kind of physical characteristics or location factors that could be driving the value up or down. So we're going to have addition and subtraction here. Then if we're comparing properties that have sold, obviously, then there are going to be differences in the market. So if you have a county in which the market is fluctuating a lot, increasing at a really fast rate, a house that sold for $200,000 might be appraised differently than a house that sold for $2,000 a year ago. So there may be time adjustments to make sure all of these sales are equitable. You'll start with your total sale price. If there are time adjustments to be made in your county based on the market, then you'll add or subtract those first. And then other adjustments, like things that are reflected of physical characteristics. So you know how we talked about those two ranch style houses that were side by side? They're both brick, they were built in the same year. One of them has a detached garage. It sold for $20,000 more than the one that is identical but without a detached garage. So we can make assumptions about what these extra additions are worth in the market in your county. When we've made all of those adjustments, what we're left with is the adjusted sale price that's then comparable to the subject property. If we have 3 different sales comparison or comps that someone brings in, for instance, we can use those to determine whether or not the appellant's property is valued higher or lower maybe than it should be. So the sales comparison approach is my favorite because there's usually so much data, especially in a county that's market is really rocking. And when it's analyzed and the adjustments are applied correctly, it's the best determination for what the market value should actually be. Obviously, the local assessor can be an extremely valuable resource. They are fully invested, they know their jobs, They can answer questions that you might have, and they want to answer those questions. They want to ensure that you can make the best determinations because that's what best serves the taxpayers in their county and their jurisdictions. Obviously, the Division of Property Assessments is always here if you ever have questions. I'm very proud to say that we have people that have very specialized sets of skills, and they are welcoming of any questions. We have resources and things at our disposal regardless of what it is you're trying to accomplish. So please feel free to reach out to us with any questions. Thank you.